All persons having business before the Honorable Chief Judge and Associate Judges now presiding over the District of Columbia Court of Appeals draw near and give your attention. God save the United States and this honorable court. This honorable court is now in session. Please come to order.
Great. Good morning, and thank you for joining us this morning for our oral arguments before the District of Columbia Court of Appeals on our virtual Zoom platform. The arguments are being live streamed via YouTube for those members of the public who would like to watch the proceedings. We have three matters set today for oral argument. The first is Tom McDonald et al. Versus DC Board of Zoning Adjustment, Tenleytown Neighbors Association versus DC Board of Zoning Adjustment. I guess before we begin, can parties briefly let the court know how you plan to divide your time this morning?
Good morning, Your Honors. This is Andrea Furster for Tenleytown Neighbors Association, and I apologize that I could not load the virtual background on my backup computer. I'll be splitting my oral argument time with the petitioner, Tom McDonald, and I'll be taking 9 minutes, and Mr. McDonald will take 4 minutes. We would like to reserve 2 minutes for rebuttal.
All right, thank you. All right, you can proceed, Ms. Forrester.
Thank you. I'm going to focus on two issues today. The first issue is that the Sunrise facility does not qualify for a special exception because it does not offer health care services, which are a requirement for a continuing care retirement community. And the second issue I'd like to focus on is that the BZA erred in granting the 3 variances to Sunrise.
Ms. Ferris, why, if I could jump in, and I know we have I have a number of questions as my colleagues do as well. Why doesn't the memory care provided for patients with Alzheimer's that are going to be a part of this facility and the services provided in the facility qualify for health care?
I think the record is clear that Sunrise is only providing what's called activities of daily living care, which is dressing, feeding, medication reminders, those sorts of assistance, none of which require any kind of healthcare services, no services that are provided by individuals who are trained and or professional, have a professional healthcare qualification.
Counsel, didn't you take a contrary position though before the BZA? I mean, I'm looking at your filing. It's on page 545 of the appendix, where you're arguing to be a CCRC, you have to provide healthcare. And then you say Sunrise emphatically states they don't provide healthcare despite the fact that they're providing assisted living and memory care, with the average age being 86 and people having dementia, including Alzheimer's disease. That sounds like you're saying, of course they provide healthcare. And that seems to have been the basis for your argument that because they provided healthcare, they could not be located in the place that they wanted to be located because that was too close to another healthcare facility. So it seems like you're changing position on appeal, which we don't generally favor.
In fact, what you're reading from is a pre-hearing submission that Tenleytown Neighbors Association provided. And that's when there was very little information about Sunrise that was being provided. So the neighbors argued alternatively that if they were providing healthcare services, they could not meet the definition of a CCRC because they were healthcare facilities. But if they were not providing healthcare services, then they would not meet the definition of a CCRC either. So that was at the outset when nothing was known about what Sunrise was doing. At the hearing, it became clear that Sunrise was not providing healthcare services. In fact, their vice president admitted that during the testimony, that all of the services that they were providing were services relating to activities of daily living, and that he did not consider them healthcare services. And at
So,
that point,
so I'm sorry to cut you off. So the CCRC sets out 3 categories of facilities, right, that would qualify. There's the independent living facility, there's the assisted living facility, and then there's the specialized nursing facility. And I guess I'm trying to understand what you think an assisted living, what qualifies as an assisted living facility that wouldn't be a specialized nursing facility, and where, and what's that based on in the
so
law?
I think if you see the testimony in the record, you see that
I'm looking for, I'm sorry, not factually, like what are the legal standards for an assisted living facility? If the DCMR defines these 3 categories and one of them really does sound like a healthcare facility if it has specialized nursing care, what's the assisted living facility, and how do we know what that is under the law?
so the definition of an assisted living facility, and I think there's a definition in the zoning regulations at 11 subtitle B, section 100.2. It provides a continuity of residential occupancy and healthcare for elderly persons. So again, healthcare is an essential component of an assisted living facility. And a trained nursing facility obviously has a higher level of healthcare services that are provided to its residents. And of course,
I'm not sure I quite follow that aspect of your answer. The definition that you're referring to in the zoning regulations is of continuing care retirement community. It does say that it is a building that provides continuity of residential occupancy and healthcare. So I get your point that to be a CCRC in the jargon, you have to provide healthcare because of the word "and." So I understand that point, but I thought Jessie's question was, I thought about the definition of assisted living facility, which is, if you go to the next sentence, it kind of suggests that CCRCs can include various kinds of dwelling units. They can include independent living units. They can include assisted living facilities, or they can include skilled nursing. Everybody agrees there's no skilled nursing here. And there's some suggestion that maybe there is assisted living being provided here. That seems to me a little bit murky. But is there a definite, and I'm not sure to be a CCRC, you have to give assisted living facilities. That's just something that can be included as a kind of unit in a CCRC. So I'm not sure that's a definitional requirement that you even have any one of these 3. Maybe it is. But is there some definition of assisted living facility that you rely on?
Again, we rely on the global definition of CCRC, which applies to each of those 3 components. That they each component of an assisted living facility must provide for healthcare for elderly persons. I think, what this, if it doesn't.
I'm sorry to cut you off. Each of them has to provide healthcare?
No, I'm sorry.
Right. I mean, because it matters, the definitions. And this is why I wanted to focus you on this, because if it's just an independent living facility, then the size is limited, right?
That's correct.
Do I understand correctly? But the other 2, the assisted living facility and the specialized nursing care facility, those can be bigger, right? And yet the definition of CCRC says, look, all of these 3 things are CCRCs. And one could read that definition to say that it means that they understand assisted living to provide some sort of health care in this context, right? I mean, maybe healthcare is a term of art under this regulation. I'm just trying to understand what the reg means.
I mean, all I can say is the plain language of the regulation says it provides a continuity of residential occupancy and healthcare for elderly persons.
Right, but then what makes this definitely clearly wrong and arbitrary and capricious for the BZA to say this building where we're going to provide memory care and have a whole wing for our Alzheimer's patients is not an assisted living facility that wouldn't be, too big for 11B DCMR 100.2.
Because it doesn't provide healthcare. If it doesn't provide healthcare and it just simply provides assistance with daily living, then it is independent living. And I can only
Let me just, can I get into my question a different way? What would be an assisted living facility that isn't a specialized nursing care facility? My problem with your argument is it seems to collapse the two of the three types of facilities that can be CCRCs and make it a binary choice. You either have independent living where no health care is really being provided, and so therefore you can only have 8 units, I think. Or you can have specialized nursing care, and that's a healthcare facility. But you seem to erase the assisted living, and I'm trying to figure out, like, what is your understanding of what an assisted living facility is? And you say, well, it provides healthcare, but I don't understand what's the distinction between the two, assisted living and specialized nursing care.
Well, maybe the better way to understand the definition is to look at the preceding term, that it is a group of buildings providing a continuity of residential occupancy and healthcare. And that's what distinguishes this facility from an independent, simply an independent living situation, which wouldn't provide any continuity of services. So if you have simply an independent living facility, it can't be for more than 8 people.
But that just doesn't help me distinguish between the two terms that I'm trying to distinguish between.
I honestly, I can't answer that question. All I can say is this definition requires healthcare facilities, healthcare services.
A related question about not distinguishing terms. So there are some statutory provisions relating to assisted living residences. And if I recall correctly, Sunrise, it does not intend to be licensed as an assisting living residence for purposes of those regulations. But that does have a definition of assisted living residence. Do you think assisted living residence is different from in the statute, is the same as or different from assisted living facility in the zoning regulation that limits the number of occupants to 8 unless something is an assisted living facility, unless it provides unless it is an assisted living facility or a skilled nursing facility?
So my understanding of the statutory scheme that regulates assisted living facilities is that too requires.
Well, again, just to be, the defined term is assisted living residence. That was part of my question is there some difference between assisted living facilities and assisted living residences, or are you equating them? It sounds like from what you just said, you might be equating them, but I just wanted to check and see whether you think they're the same or different.
I don't know that they would necessarily be different, but in both would require some form of healthcare services. Otherwise, you're simply doing what many people do with their elderly relatives, which is they provide them with assistance with activities of daily living in their in a home, which is not a facility, and with being cared for by relatives or other unlicensed non-professional caretakers.
Right, Ms. Forrester, I didn't mean to interject, but I am conscious of the time, and I would like to move you to the issue of the variances, if you were going to address that. Yes. And I also, if not, we do have to leave some time for Mr. McDonald. If you could talk a little bit about the variances, and I'm in particular interested in your assessment of why it doesn't meet the 3-pronged test for a variance. But more importantly, if you could also address whether we get to the issue of the public good flexibility and discretionary prong of the analysis here.
Sure, and I think the core problem here with they don't meet any of the 3 tests for a variance, but focusing on the first 2 tests, apart from the public good, I mean, you don't get to the public good unless you've established an exceptional and unusual condition or attribute of the property that that causes a practical difficulty. And all of the attributes of the property that are identified by the BZA do not cause any practical difficulties. They enhance the developability and the ability of the church to monetize its property because it is a large size and has street frontage. So that's the first criteria, is they don't.
Well, but isn't there a practical difficulty with respect to the church of the need to downsize, decrease in membership, historic nature of the church congregation? Why wouldn't that satisfy some of the practical issues? And if that alone doesn't satisfy it, why can't you look at the symbiotic relationship between the two entities, Sunrise and the church, to satisfy that prong?
So on the practical difficulty prong, you have to meet both of them, but just, putting aside the fact that the lot size, and there's no attribute or condition or situation of the lot that causes any practical difficulty. Sunrise has a financial problem because it has a dwindling congregation and it needs money to address the fact that it is not able to maintain its facility currently. And so that's the practical difficulty that the church has identified. But the problem here is that what the BZA relied on is Sunrise's practical difficulty. Sunrise is a multinational for-profit entity, and it's not even an owner of the property. So a non-owner cannot request a variance. And I think the Foxhall Community Association case makes that clear, is that you only look to the church. And whether or not—
Ms. Forster, on that last point, that sort of Sunrise is categorically ineligible to be part of this variance application, that was raised in front of the BZA. I did not see that argument raised in your initial brief, and I don't think that the interveners respond to it because it hadn't been, I didn't see it raised. Do you think it was raised in your opening brief? I saw it raised explicitly in a footnote in your reply brief, but I didn't really see it in your opening brief. Did I miss something?
No, it was raised indirectly in the sense that we have, our opening brief very extensively argued that Sunrise's Sunrise as a for-profit entity, its needs, its personal needs, were completely irrelevant for additional size and flexibility. Were completely irrelevant to the variance application and the variance standard.
But is that correct to say when, how can you look at, if this is a joint effort, it is one site being developed jointly, meeting multiple needs of both the church and Sunrise, at least as it's presented to us. Why is it appropriate under this analysis to disregard completely what Sunrise's arguments and needs might be? And even if we were to find that prongs 1 and 2 weren't satisfied, what's the detriment to the public good here on a lot of this size that is sort of buffered by park space and other areas where we don't necessarily see from the record, or you can point it to me if I'm wrong, the detriment to the public good? Or do you have to meet all prongs? I guess this is a multi-level question I'm asking.
Right.
If we disagree over that prongs 1 and 2 are met, is it enough that prong 3 is satisfied so that there is no detriment to the public good?
So starting with the first part of your question, I would simply answer that without Sunrise is not entitled to public service organization flexibility, and without public service organization flexibility—
Why not? That's a big question.
It's a for-profit corporation, and there's not a single case in which public service organization flexibility has ever been extended to the needs of a for-profit.
Well, we have some cases that discuss this with the Republican National Committee, and I believe it was Monaco, and then there's another case dealing with the Black Child Development Institute, a synagogue, where we've looked at this issue. And, is it seems to me the test is a little mushy, where there may be some room here to show that the church, there are some findings in the record that discuss the public good that the church does. There are some findings and conclusions in the record of the BZA talking about the benefit and public good that Sunrise provides, even though it provides it for profit. So it seems like there's some room in the tests that we've laid out in DRAWD 1 and 2, in Monaco, and in some of our other cases to at least consider whether there's some public good here.
I don't think so, for two reasons. One is that the case there's not a single case in which any of the what public service organization flexibility has been extended to a for-profit entity. And second, on the public good issue, let's remember, number one, that Sunrise is providing luxury housing for elderly people who can afford it.
That's market rate. I think it's described as market rate housing. Suppose they had low income facilities, a number of rooms in the facility set aside for below market rate or for low income seniors. Would that allow it to be qualified, even though it's a for-profit company, under the public good or public service flexibility exception?
I don't think it would. I think the church, second of all, in terms of the public good, the church's mission has never included providing housing to elderly, much less market rate housing for elderly. I think this is an unwarranted extension of the public service organization flexibility. If you say providing a small amount of low income housing gives you public service organization flexibility, well, that applies to just about every residential property.
What about the church food bank and other social services for the community in conjunction with the senior housing that is being provided in the Sunrise component of this property?
I don't know that Sunrise provides any services to the community beyond market rate housing for elderly people.
So can I just ask, are you saying, you say public service organization flexibility can't be extended to a private for-profit entity, but I'm wondering if you're saying that if the for-profit entity is in partnership with a not-for-profit, then that cancels out any eligibility for the not-for-profit. Is that what you're saying? So
No.
even if the church could get public service organization flexibility because it's decided to join forces with Sunrise, that's off the table now? Is that what you're saying?
No, I'm not arguing that. I think, the Foxhall Community Association case, well illustrates how you should take into account a partnership between a church and a for-profit entity. And in that case, this court made very clear that the only needs that should be considered are the church's needs. And it did not consider in any way, shape, or form the needs of the condominium association that it wanted to partner with in order to
but the church's needs, though, the church wants to stay, right? And the church wants to be in this location. And it's figured out that one way that it can do that is by joining forces with Sunrise. And it seemed like in your brief, your argument was, well, the church could sell, it could subdivide and sell. But if the church wants to stay in its location where it's been for decades, why then can we not take this into account, that it's figured out this is a mission, they say this is mission compatible, providing, a place for people to live after they're no longer able to live in their own homes and stay in the neighborhood where they've been living. They don't have to be displaced. Why is that not a public good?
The answer to that is that the church has not shown that the need for the variance is based on the unique operational model of Sunrise, which requires more space for the type of services it provides.
Well, but it's also needed for the church to be able to stay where it is, to continue its mission and its historical role in that community, isn't it? It's a two-pronged need for this variance, isn't
The
it?
church needs to show that there's no other way for it to address its needs other than these excessive variances being offered to Sunrise for 85 units. And we have pointed out that in fact, continuing, it could get a matter or an assisted living facility that would not require a variance.
What's the law that you're citing for the support as support for the proposition that the church has to show that there's no other way? I'm not sure that I read our cases that way, right? I mean, you know, if we said back in the clerics of Saint Viator, am I pronouncing it correctly? That, you know, the seminary that was trying to convert into a nursing home could show hardship by showing the inability of the applicant to make a reasonable disposition of the property for a permitted use. And it seems like the CCRC is a permitted use if we get over the hump of, you know, are they actually an assisted living facility? And you know, it seems that they're just trying to make reasonable accommodations to make this permitted use fit on the property, you know, so that it's set back from the neighbors, so that it, you know, can put the parking underground.
I mean, I think the record is clear that that the church wants to monetize its property to the maximum extent possible, although it never stated how much money it needs. So the problem here is that we don't know, based on this record, whether or not a contract or a sale, a partial sale to another CCRC with a smaller number of units that would operate without a variance would not satisfy the church's needs.
But I thought it was in the record that they needed to be financially viable, they needed 86 units or 85 units.
Sunrise needs 86 units, but we're
well,
talking.
But the church needs Sunrise. I think that's what the chief has been getting at, is that this is a partnership. And so if Sunrise needs 85 units to join forces with the church, then the church needs 85 units. That was credited. I don't, or you think that that's not supported by the record?
I think that if you accept that a church can basically say that that a variance is allowed for anything that would give the church and, you know, whatever it wants, then you're basically opening the door for churches to sell their property for condominiums like the Foxhall Community Association did.
Ms. Forrester, sorry to interject right here, Ms. Forrester, but you said something that intrigued me. What if here the church owned the property, and instead of partnering with Sunrise, leased Sunrise the property to build the units? And that way the church got, I guess, more direct line of the income as a lessor, as opposed to a partner in this joint venture. Would that change how you view the variances? Because the variances would then be for the church, right, to lease the property, or would that get us further away, in your view, from what would qualify here as a variance?
I think the variances are unique to Sunrise's operational model. Other CCRCs do not require variances to operate CCRCs for a smaller number of residents on smaller lots. And I think if the church changed its mission and decided that it wanted to go into the business of providing elderly housing, and it requested a special exception, and then the issue would become, you can provide elderly housing on this lot for a smaller number of people without a variance. And I think the case law is pretty clear that in order to get an area variance, you do need to show that there are no alternatives that would address the economic situation. And I think clearly in this case, there are alternatives.
Right. Ms. Forrester, I know you've reserved some time for a rebuttal, and our questions have taken you over your time, but I do want to give Mr. McDonald an opportunity. I think he had said 6 minutes for his argument, and we'll give him some flexibility.
Good morning to the panel. May it please the court. I'm attorney Tom McDonald, counsel for the petitioners. Typically at the appellate level, it's an argument about the law. But here it's about not only the law that we've been hearing about, but also critical facts, facts that have been misstated by Sunrise that need to be promptly, and I will get to that, clarified. First of all, Sunrise at great length in its papers talks about how this project will meet the needs, the housing needs of elderly in Washington. That is false. This is, with all due respect to your honors, this is housing for the wealthy at $8,000 per month, $8,000 per month. We can call it market rate, we can dress it up, we can say whatever it is, but it's a lot of money, and most in that neighborhood, and I'm a 200-footer there,
Mr. McDonald,
could never afford it.
can I ask you what I asked Ms. Forrester out of curiosity? Would your assessment and analysis change if a certain percentage of the units at the Sunrise facility were allotted or set aside for low-income seniors, which is what a number of development projects around the city have done?
To the Chief Judge, good morning. That is certainly an intriguing option at a significant number of low-income elderly. You know, we have seen the demographics of the city, and here again, they want expensive housing. They have a business model, but the Chief Judge makes a good point. I think sending this back to the BZA, having the project redone, looking at potential low-income elderly is something worth examining. Point number two for me, again,
Was that ever raised before the BZA?
Say that again.
Was that question ever presented?
No, and it's been papered over. Mr. Koskin, their main spokesperson, I was at every ANC meeting, Chief Judge, and he did not directly address really any of the hard questions here, and frankly was unhappy with the insistence on all the neighborhood input. So this was not taken up previously to the Chief Judge. So second of all, Sunrise claims there's real support for this outsized project, 85 units on less than 1 acre, very dense, persons with, you know, illnesses, and we're obviously still into COVID, but on less than 1 acre, between staff, visitors, you could have up to 300 persons a day through these 85 units. Sunrise has claimed falsely that there's real support for the project in the community. I would direct the bench to the appendix, Exhibit 49, where over 200 residents, homeowners, actively, officially oppose this project, and have been on the record of that for years. I only know of one family, the Ben Nussdorf family, that supported the project, and he moved away to the judges here. He moved away 2 years ago. I would go on with some other critical facts, and of course, at the appellate level, it's just not about the law.
Mr. McDonald, before you move off that,
they can look at the facts.
Mr. McDonald, before you move off that, what do you make on the issue of community support of what the apparent support provided by the ANC, which is something that the BZA is required to give deference to?
Yeah, I think they Thank you, Your Honor. Very good question. With all due respect to the ANC, and a number of us were at these meetings, there was like 100 people at these meetings every time. We felt the ANC was steamrolled. The ANC in Ward 3, obviously, this is a court, you tell the truth. This ANC in this particular area has been steamrolled repeatedly by developers. And this really, yes, the ANC endorsed it, and it went through some paper dressing it up, putting lipstick on it. But it's still an outsized, overly dense project. Your Honor, if I may, there were two. So when you look at their reply brief, they've got a whole page about how it's helping housing in Washington for seniors. It's not. Then they go on for another whole page about what Andrew
Why is it?
had
I
to
mean,
say.
at the very least, it is providing housing for seniors. How could you say it's not helping?
Not affordable housing for seniors at $8,000 a month, Your Honor. Sure, it's providing housing. I admit to that, but it is not. We know how expensive Washington has become, and again, to the Chief Judge, I appreciate your comment, suggestion, and when this is sent back down, that they look at making this a mixed-use project with low-income seniors, but they rely upon Mr. Andrew Altman. I'm not sure what neighborhood he was in, with all due respect, a former director of the Office of Planning. And by the way, I'm a former employee of the DC government under the Walter Washington administration. But in any event, you would think by his description that we're talking about us living in the middle of Wisconsin Avenue. Come up to Tenleytown, come to Alton Place and 39th Street to the bench. It's quiet. There's nothing going on there. So his comments, with all due respect to him, should be dismissed. Also, the Honorable Frederick Hill, chairman of the BZA, sort of set up a straw man, said, and the bench has already gotten into this with Ms. Forrester, well, what about another church, or what could this, the neighborhood could face a large church. As far as I know, that'd be fine with the neighborhood. Let Sunrise join with another church and make a bigger church to make it more financially viable. But that's not the proposal on the table. With all due respect, the proposal on the table is housing at $8,000 a month. Another point here, and God bless us all, we hope COVID will end someday, but not one moment, not one word to the bench was considered about COVID and the impact that this project could have on a neighborhood. And to clarify you've all probably ridden by our neighborhood. This project will be within like 5 feet of a house on one side that has a 1-year-old child. And so with COVID, with the Delta variant, the literature that's out there now talking about this going on for the foreseeable future, this project could become a super spreader. And with all due respect to the Court of Appeals,
I'm sorry, I missed the part about how this becomes a super spread. I think that there wasn't any evidence in the record about that.
Well, we didn't have COVID then, Your Honor. That's my whole point.
Well, I know, but we're constrained by the record.
No, but if you set this back down, excuse me, I'm sorry.
As it exists before us now, and so I just, if there are any other legal arguments that you want to address.
Sure. I mean,
you also have some time for rebuttal, so I do want to make sure.
Yes, Your Honor. Just wrapping up, as Judge McLeish had indicated, well, wasn't this taken up at the ANC? Well, we didn't have COVID then, and I'm sure that would have been, the record would have been replete about it, but this is dragged on for so long. So Thank you very much. And my remarks.
Mr. McDonald, can I just ask one clarifying question? At the very beginning of your argument, you said
Sure.
that you were representing others. My understanding
My
was that
family.
you
My
were
family.
representing yourself and your spouse.
Yeah, my family.
Okay.
Yes. Right.
Thank you.
Thank you.
All right, thank you, Mr. McDonald. At this time, we'll hear from the interveners. Ms. Baum.
Thank you very much, Your Honor. May it please the court, Deborah Baum on behalf of the interveners, Wisconsin Avenue Baptist Church and Sunrise Senior Living LLC. I have to articulate some surprise at the nature of the arguments today, as the court, of course, acknowledges typically, and Mr. McDonald acknowledged typically, arguments at the appellate level are about the law. I was listening for any arguments from Mr. McDonald about the law, and instead, I think broadly, his argument characterizes the petitioner's arguments in this case. They are asking the court to do what the court has repeatedly said it will not do, which is to reweigh the evidence. Mr. McDonald just said the comments of Andrew Altman, a former director of the Office of Planning, who testified at length about this project and how important it was for the city and how he very selectively almost never testifies on behalf of any development project. He felt compelled to do so here. He just tells the court you should dismiss those comments. He accused in his reply brief and to the court today, Sunrise, of mischaracterizing facts. I was going to highlight for the court, but Judge McLeese got there first, that in fact, when Mr. McDonald says it's not true that many families supported this project, as he said in his brief, it was more like 5. The ANC, which he acknowledges, but says they were steamrolled.
Ms. Baum, may I interject briefly? I'd like, if you could, on behalf of the church as the intervener, address the variance prongs that we've been talking about, and whether you think under our statutory scheme for variances, how the church qualifies individually or in association with Sunrise. If you could go through the, and then also as a part of that, talk about the public service or public good aspect.
Absolutely, Your Honor, I'd be delighted to. And in fact, in that argument on institutional necessity and the public good, again, that is thematically where the petitioners have made really what are more factual arguments, but I will address as an initial matter, their argument seemed to be, and it came forth really strongly in the reply that on the institutional necessity, that as a factual matter, the church really doesn't need to be there because the BZA found in explicit detail that the institutional necessity and the practical difficulty and the extraordinary circumstance all related to the church's need to provide its mission and to has a right to want to continue to be in that neighborhood where it has been for 100 years or more. And
the findings by the BZA that are in the record, I believe at paragraph 5 of the BZA decision, are those sufficient? That's where the BZA talks about the program to feed the homeless and other services that the church provides. Are those sufficient under our current cases to qualify the church as a public service entity?
They are, Your Honor. They're much more extensive than, for example, the one case where the court, and you may be thinking of, I wanted to mention in particular the DuPont Circle case, because I heard a lot of argument from Ms. Furster about how you just can't, it's never been extended to a for-profit, never, ever, ever. And I think it's important, 2 cases that were mentioned during her argument, I think are important to talk about here. One is the DuPont Circle case, and that is one in which a for-profit developer, not providing senior housing, providing luxury condominiums, partnered with St. Thomas Church. And what the court said in that case, there was never a follow-on remand hearing. I know because I represented the developer in that case. The matter all got resolved shortly following the court's issuance of its opinion, initial opinion, which said there was basically one line in the BZA order there that said the church needs to do, I can't remember the exact language, but it was essentially one line saying the church needs a new sanctuary and it needs this, and one finding. There was nothing, and the court simply said, look, it's not a stretch, was the court's language. It's not a stretch to imagine that the public good exception will be extended to this circumstance if you can show exactly what the findings were here in this case. But you need to make the connection between what the church needs and what the developer, in that case, a for-profit developer, was going to provide. There was not a hint of you can't do this because it's a for-profit developer. So in this case, the fact that Sunrise is a for-profit entity is completely irrelevant under the holding in DuPont.
Can I ask you just to see how far you take that? Just to imagine the following situation. Imagine that I am a for-profit real estate development company, and I own a piece of land that has a building on it. And I, for the last 10 years, have leased that building to a nonprofit, a church or other kind of nonprofit that is working there. And I decide I want to expand my building, and I want to keep the current tenant. And the current tenant is saying, look, we need to, we want to expand our public service activities on your site. And so then I am I'm the property owner, the only property owner, and I file a variance request, and I try to get public service, public service, public interest flexibility to get the variance. Can I get it on the theory that, I'm a for-profit entity that owns the land and will continue to own the land, and it's my building and I'm getting rent and profiting off of it, but I happen to be leasing to a nonprofit that would like the variance to expand its activities. Does the doctrine extend that far in your view?
Those are different facts. I mean, here.
I'm well aware they're different. I'm just trying to figure out how far you take your line of thinking.
Well, I don't think it would go that far because, for example, you don't know how long the lease is under your hypothetical, Your Honor. I mean, that could get you into the Foxhall case. Another distinction is Firster tried to analogize this case to the Foxhall case. In that case, what happened is the developer brought the land from a not-for-profit, a public good church, and then essentially bought it, and the church was going to leave, wasn't going to be there anymore. And what the court said there, it's completely different situation from this one. And that's why I say in your situation, Your Honor, it might not extend that far, because it would depend on whether the not-for-profit use on the for-profit developer's land said, yes, we really need to expand our activities. We're going to be here for the duration. We're going to own part of it. Like in this case, the church and Sunrise will own it together as fee owners because they're creating essentially a condominium to separate out the ownership, but they will own the property together in fee. And so I think depending on the facts under Your Honor's hypothetical, Judge McLeese, it could or could not extend. I think it would depend on those facts. To be clear, if it were like the Foxhall case, which again, Ms. Firster tried to analogize to our case, it would not apply. That's the case where if Sunrise were saying to the Wisconsin Area Baptist Church what the petitioners are saying, you don't need to be here. You can go someplace else. And you will go someplace else, but we want your land and we want to use your not-for-profit status to try to get a variance. That doesn't work. That doesn't work under Foxhall, and that's not what we're doing here.
I get that. Can I ask you another question about, is it essential to your prevailing that the BZA reasonably viewed what Sunrise is going to be doing as itself contributing to the public good. And so, again, a slightly different hypothetical, and I know this wouldn't qualify as a special exception, or I assume it wouldn't qualify as a special exception. But imagine the record was like this. The church is here, it has a dilapidated building, it would like to stay on site, it needs to get economic benefit from the property in order to finance, to have a living space it can use, or, and to finance its activities. So it's entered into a contract where it's going to, have a single building, and it's going to have half the building and the other half is going to be a McDonald's. And so it's a purely commercial enterprise, no real specific contribution to the public good. It's just that it'll generate economic value that will allow the church to remain on site and perform its activities. Would that also be okay in your view? Assuming it were a special exception, I know it wouldn't necessarily be, but assuming there was a need for a variance to do that. And the argument was, we're a church, that's a public interest activity. We need to do this. We need to generate the economic value in order to remain in our activities. It doesn't really have to be independently valuable economic activity. It's just going to all flow through and support us. Is that okay too? Or is it critical to your view that the activities of Sunrise be viewed as specially contributing to the public good?
Well, I think it's not critical because it wasn't critical in the DuPont case. Those were luxury condominiums that were going to be built to help St. Thomas expand its use. And the court said, not a stretch to consider the public good doctrine applies here, but you need to go back and dot your I's and cross your T's.
We expressly held, I get your point that you can infer from that case that maybe we would be open to that way of looking at it. I'm not sure it was a square holding that's okay. It points perhaps in that direction, but your view is not essential. It could be a McDonald's if that would fit as a special exception.
Well, and in fact here, the cases have been very clear since Monaco. And in fact, it cited even an earlier case where the court said on this issue of extraordinary conditions, you can look not only to the use of the nonprofit, but the additional use, and that's under Drawd as well. You can look to the successor use. I would also point to the St. Mary's case with respect to your question, Judge McLeese. In that case, involved Hillel, and Hillel, of course, was the nonprofit. There were 2 floors above it that were leased to GW.
GW was a nonprofit educational institution, I thought.
It is, but there wasn't a lot of testimony. There was no argument, at least that I recall in that case, about GW's use providing some special public good. And in fact, St. Mary's argued to the contrary. They said, look, GW, this isn't for the public good. These 2 floors, that's exactly what St. Mary's argument was. These 2 floors, the additional 2 floors that you're trying to get your variance for are not for the public good. They're just GW leasing more space. And the argument that the court accepted from the interveners was, no, it doesn't matter, because the testimony was you have to lease that space to GW to make it, GW has to be able to do that to make it financially viable. And for it to be financially viable is critical to allow Hillel to do what it needs to do. It's the same situation as here, only with Sunrise. There's a lot of testimony about the importance and the public good coming out of that as well. But under the very clear case law from this court, you get to look at both. And you have detailed evidence about both here under the various.
Ms. Baum, I'm sorry, I was on mute thinking I was asking a question. Do you think that the GW case or the RNC case are more closely analogous here? I think RNC case was the Monaco case, and then there was the Black Child Development Institute case. Tell me how this line of cases gets us to finding under our law that there is a public good exception here, even though we do have a for-profit institution with Sunrise that is not doing low-income housing. It's only market rate.
Well, and to be clear, that wasn't an issue. The low-income housing was not an issue. It's simply not required under the zoning regulations, where for a lot of multifamily projects it is. So you see it in a lot of those projects. I don't know whether the policy underlying the no need to require that is that they're already providing an important public good in the availability of senior housing. I mean, make no mistake, the DC Office on Aging understood fully the economics of all of this and ardently supported this project, as did the Office of Planning. There was no mystery surrounding the economics. But in direct answer to your question, Your Honor, I think the St. Mary's case is more on point. I like to think that the uses here relate more to, I mean, some of the exact same arguments were teed up. But with respect to the RNC use in Monaco, I certainly like to think that what Sunrise is providing at this site is more valuable and more important in terms of location and the condition of the property and the site than it was for the RNC in Monaco. But in the
Counsel, I know your time just expired, but we give your opponent some additional time. And I would like to make sure I hear from you on the special exception question. And can I start the discussion of that by just asking you a question about your position? Is it your position that the facility will provide healthcare?
Yes, Your Honor, that it will provide some healthcare services, but I'm happy to.
Yeah, so I just want to make sure I got an answer to that bottom line question. And do you agree that in order to qualify as a CCRC, your facility needs to provide healthcare?
No, I don't. And I also don't think if I may try to quickly sort of summarize this in a nutshell, the whole healthcare facility issue, the petitioners have tried to set up a heads we win, tails you lose. They argued in detail prior to the hearing, and Judge Easterly quoted from one portion of their filing. But if you look at record page 657, it's page 118 of their pre-hearing submission, they say specifically, and I quote, Sunrise alleges that they do not provide health care, but it is difficult to envision a facility with 121 people at an average age of 86 years old, and the majority will be admitted for dementia, including Alzheimer's, and yet Sunrise says there will be no health care provided. And I think—
Well, can I ask you that piece of your summary seems directed to the question of whether this issue was adequately presented in the trial court. And there's no question that they were making as one of their points, if there is healthcare being provided, then Sunrise is the facility would be a healthcare facility. And then you get into questions of spacing from other healthcare facilities and additional requirements. So they definitely were making that point, but they contend that they were making in the alternative, because they're obviously inconsistent, the argument that to be a CCRC, Sunrise has to provide healthcare services, and that where is the evidence that it does that? And you dispute that they presented that as a freestanding, though alternative to another inconsistent argument, but a freestanding objection. Sunrise, to be a CCRC, Sunrise needs to provide healthcare, and where is the evidence that it does?
it was certainly not the argument that was presented up front at the hearing. Now,
let me ask you about that, because let me point you to Joint Appendix 88, where the attorney representing the interveners, I want to make sure I'm on the right page, says, this is at line 7, page 515 of the transcript on that hearing date.
Right.
The opponents also stated that Sunrise does not provide health care and therefore is somehow not in compliance with the CCRC definition.
Yeah.
Do you agree with that?
Yes, no.
That seems to suggest that the attorney representing your clients at the hearing understood that there was an argument there that needed to be addressed. Am I misreading that question? Or?
No. Absolutely not. And that's why I was saying, I think the big argument they were presenting and a lot of the testimony related to their testimony and their argument had been, I don't dispute that they raised that question. I think you're right, Your Honor, that at least
so
was
clear, because your brief did, just to be clear, your brief did dispute this. You're agreeing that the issue is adequately raised in front of the BZA, whether Sunrise, it qualifies as a CCRC and therefore is eligible for a special exception because there just isn't enough evidence that there was healthcare services were going to be provided.
Well, Your Honor, I'm not going to dispute that point because I read that language on that page. I know that at the hearing, the BZA obviously understood their principal argument to be otherwise, because that's how they addressed it in their order. But was it raised? It was raised in a filing, prior to the hearing.
Well, I thought you also acknowledged it was raised in the post-argument submission.
In the post-argument submissions, yes, absolutely.
Okay. And so we get to so leave that aside for a minute. And focus on the merits of that issue.
Yes.
And let's talk about the answer on that page, because the witness for the interveners says, and it seems like there's some confusion, again, because of the alternative arguments and the somewhat nuanced difference between providing healthcare services and being a healthcare facility, that the witness first says, well, we're not a healthcare facility, which isn't the exact question that was being asked, but he's not necessarily a lawyer, so he's not, parsing all of that. So the lawyer says, but you do provide some healthcare to the residents, of course. And Mr. Heath says, I don't qualify it as healthcare as much as I qualify it as activities of daily living and personal care. And your opponents say, the intervener's own witness says you're not providing healthcare. And therefore, the BZA was wrong to, without much discussion, seem to assume you were providing health care. And I'm just interested in your response, both to the evidence that you are providing health care and the adequacy of the BZA's explanation of its conclusion that you were.
I think what the witness was focused on, obviously, and sort of, I think, crossed wires with the lawyer questioning him. He says from that same page, Joint Appendix 88, he said, again, I don't qualify it as healthcare as much as I qualify it as activities of daily living and personal care. But again, I think it's hair splitting. I think the healthcare definition doesn't include our use. So he's talking about it from a use standpoint and a healthcare facility standpoint. It sounds to me like what he was getting at. But more importantly, the BZA can believe or not believe or agree with or not agree with whatever testimony it decides is compelling. And in this case, it decided that there was healthcare, what it viewed in interpreting and applying its own regulations, what was healthcare.
And where would I find the BZA?
Yeah, where would we find that? If we could get back to the law, what is an assisted living facility? What is healthcare? Is healthcare a term of art? Is healthcare sort of what we commonly think of as healthcare? What is that?
Healthcare is not defined in the regulations. And so under the regulations, under section 100, 11B DCMR 100, section G, words have the meaning in Webster's. And so we cited the meaning in Webster's. And it's the same thing with respect to assisted living. Assisted living isn't defined in those regulations. And assisted living is defined in Webster's as, and I quote, a system of housing and limited care that is designed for senior citizens who need some assistance with daily activities but don't require to live in a nursing home. And I think that's how a lot of these facilities are, this continuum of care is commonly understood. The independent living.
Do you think that the regulation is internally inconsistent?
I don't. I think that what the BZA, and I understand why you're asking that, because it says provides health care in the definition up front. I think the BZA actually did a very good job of kind of synthesizing the whole thing by noting that the application in paragraph 10, finding of fact 10, Joint Appendix 17, the BZA held specifically that they concluded that the application meets the definition of an assisted living facility, CCRC, because it will provide residential accommodations, assistance with daily living, healthcare services, and memory care for elderly persons over 60 years of age.
Right.
And do you meet the definition?
I see that, but I'm just trying to figure out what the basis is for that conclusion, right? And that's why I'm going back and, in the absence of any other definitions, we're kind of stuck, I guess, with the plain language of the DCMR, unless we look outside of the zoning law to other, DC code provisions regulating healthcare facilities, which I take it you don't think that we should do. So then we look at the plain language and it says, a CCRC is a building or group of buildings providing a continuity of residential occupancy and healthcare for elderly persons. Right. So you've got the continuity of occupancy and healthcare, but then you have these three categories of independent living, assisted living, and specialized nursing care. And I'm trying to make sense of what that means.
Well, I'll tell you how as you can imagine, I've thought a lot about this question. And I think and the reason I said that I think the BZA did an excellent job of synthesizing it, is that as I read that provision, it's talking about a building or a group of buildings that this class of use, CCRCs, collectively provides a continuity of residential occupancy and healthcare for elderly persons. It really doesn't say that each one has to provide that whole continuum, because everyone knows.
Is it your point that you think then if your proposal was to have two different buildings, one of which was where the retirement community was located, and next to it was something that was different, that sort of a little mall that had some things that it might be good for people to be able to have convenient to them, that would be a florist and some other things. You would say that whole thing, that whole group of buildings could be a CCRC, because the first sentence in the definition doesn't require that each of the buildings actually provide continuity of residential occupancy and healthcare, as long as taken collectively, they're a set of buildings that somewhere in there, one of the buildings is providing that service. Is that your first point?
Not exactly, because I think the regulations go on to say that in order to qualify as a CCRC, and this is under not under 100.2, which is the broad definition of CCRC collectively, but then it goes on to say under qualified uses, when you start talking about the special exception, to qualify, you must include one or more of the following. So you must include dwelling units for independent living, or assisted living, or a licensed skilled nursing facility. And the reason I say, I think synthesizing the whole thing and making sense of the whole scheme together, which you have to do when you're analyzing statutes and regulations, I think if you read the CCRC regulation, the definition, the broad definition of a collectively CCRCs, a building or group of buildings providing a continuity of residential occupancy and healthcare for elderly persons. Independent living is independent living for seniors. And so that's at one end of that continuum.
Well, you would agree, would you agree that if I wanted to, if your plan had been only to provide independent living, do you agree, and it was undisputed you weren't providing any healthcare services, you were just saying, we're going to provide a place for seniors to live. It would be limited to seniors perhaps, but that's about it. And it was designed, to be well suited to that. Would you think you could be a CCRC and available to fit under that exception?
I think we would be a CCRC because the CCRC more specific definition, the more specific under 203.1 F1 says, as as recounted by the BZA at Joint Appendix 17, says to qualify as a CCRC, you must have one of the following, one or more, independent living or assisted living facilities or a licensed skilled nursing care facility. One of those.
Well, I think that's the only thing you need, as long as to say you must meet one of these three requirements unless there's no other requirement elsewhere in law doesn't tell you. So what you think is that kind of implicitly eliminates any requirement in the definition of CCRC in the first sentence that you provide healthcare.
I think that the best way to rationalize all of that read as a whole to make sense of it, which you can, is that collectively CCRCs provide this continuity of residential occupancy and healthcare. It's a continuum.
Is that the view the BZA took, or would that be, if we were going to accept that view, would we have to run beyond anything that the BZA said?
No, I think the BZA found that there was healthcare. I don't think it said you have to have healthcare, but it says basically,
My
as,
question was more, did
I
the
think they're saying-
BZA say we don't have to, that you don't have to have healthcare? And I think your answer is it didn't say that. Then I just want to have one, I asked a compound question, and quite appropriately you addressed a half of it, but there's another half of it I want to make sure that you address, which is,
All right.
that's not a complaint at all. I asked you a compound question and you waded into one half of it. So no complaints. Where, to the extent there are these questions that have been asked about, what is healthcare? How does it relate to assisted living under the relevant statutes and regulations? And what is the evidence in this case that supports a conclusion that there was healthcare under those provisions correctly understood? And how does the testimony of Mr. Heath fit into that? Where would I find an explanation from the BZA about those topics, assuming they were adequately raised, as it seems to me you have acknowledged in argument today they were? I certainly see the BZA saying from time to time, there's healthcare provided here, but what I don't see is an explanation if the issue was raised and disputed about why the BZA is saying that, what the applicable understanding of the relevant regulations and statutes are, and what the BZA's understanding of the factual evidence on the point was.
Okay, I'll answer the question directly, since I really inadvertently neglected to mention this part last time, but then I'm going to tell you why I think it doesn't matter. First, at finding of fact 10, as I referenced earlier, the BZA specifically said it meets the definition of assisted living, and here's why, as I quoted earlier. In finding of fact number 44, the BZA said provide 24-hour staff trained in Alzheimer's and dementia care. And in finding of fact, and it's more detailed than that. And in finding of fact 39, there's a reference to, actually, let me make sure that these are findings of fact, and oh yes, findings of fact and not conclusions of law. Finding of fact 39, the BZA specifically talked about medication reminders. And if you look at, as we cited in our brief, the Webster's Dictionary of Healthcare, since healthcare isn't defined under the zoning regulations anywhere.
No, understood. Just to flag one point of your answer, up to what you just said, you were pointing us to things that the BZA said. When you start talking about, the Webster's definition of healthcare and how it applies to these circumstances, I think you may have had liftoff from anything the BZA said, and you're flying on your solo right now on that. Is that fair?
Yes, the BZA did not talk about the Webster's definition of healthcare, but I would submit, Your Honor, that, again, the goal of the petitioners here has been to delay this case. It's been years. This case was presented to the BZA in 2019. I think it would, even if the court were to find that the BZA in a perfect world should have buttoned that up and explained in detail how it met the healthcare regulation or the language in the broad definition of CCRC, I would submit that it would be harmless error, because there's ample evidence in the record where you're talking about a Webster's Dictionary definition of healthcare. I don't think it takes any great analysis to determine, as the BZA did, even though it didn't explain maybe that this is the Webster's definition and here's how we got there. They're saying giving medication reminders and providing Alzheimer's care is healthcare.
Can I ask you,
I
over time, but there's one other doubt I wanted to or I just asked you a direct question about, which is does your facility, is it your understanding that your facility meets the definition in the DC code, the statutory provisions of an assisted living residence?
Yes, Your Honor. And it's very similar to the Webster's definition that we talked about earlier. And just one last point on why this all doesn't matter, because, again, I think a very reasonable interpretation, perhaps the only one that sort of synthesizes all of the statute and the regulations together, is this concept of a continuum from independent living. Because if independent living, if you only have to have one or more of independent living, assisted living, or skilled nursing, if you can have independent living and it's a CCRC, it seems unreasonable to think that that has to provide healthcare, because independent living is independent living. It also doesn't seem to be, as I said, a leap of faith to determine that, as the BZA did, that medication reminders and Alzheimer's care are healthcare, broadly healthcare services. So I think either way, it doesn't matter. And even if the BZA then, if somebody says, well, you should have then found it to be a healthcare facility, I want to make sure that the court understands, and we have this, I think, in a footnote in our brief, that under the regulation for healthcare facility, again, it doesn't matter, because even if it's a healthcare facility, which we think there's a big difference between providing, like school nurses put Band-Aids on kids' knees. They're not a healthcare facility, they're a school. This facility will provide some, broadly speaking, healthcare services, medication reminders, Alzheimer's care, and things like that. But even if it were then deemed a healthcare facility, under the regulation 11U DCMR section 203.1 small I6, the regulation saying you can't have a healthcare facility within 1,000 feet of another healthcare facility, it's the important last point, subsection 6, unless you show that the healthcare facility will not pose issues due to traffic, noise, or its operations, the same criteria that are required under the special exception and on which the BZA made detailed findings. So that's why I think this healthcare issue is really a big non-issue, and perhaps a clever effort to further slow down much needed senior living in the District of Columbia.
All right, thank you, Ms. Baum. We reserved some time for rebuttal for Ms. Forster, and so we'll give you 2 minutes of rebuttal and a minute for Mr. McDonald.
Thank you. Just to the point of delay, petitioners are not responsible for 1 minute of delay in this case. The BZA took its time in issuing its written decision, and it's entitled to do that. We have no responsibility for that. On the point of the variance and the whole question of, is this basically the tail wagging the dog with the church asking for a variance for Sunrise's facility? And I think this is a case that's very distinguishable even from the dicta in the DuPont Circle case. The church is occupying 16% of this facility. There's no evidence that the church is providing any services to the community, feeding homeless, even daycare anymore.
Well, but there was a finding in the record, I believe at 5, of some of the programs to feed and other services that the church provided.
In the past, but in the new facility, the church is simply going to be having office space and a non-denominational shared chapel. Its ministries, I believe, will be conducted now elsewhere. The child care facility that was used to be provided at the church will no longer be provided. So there's a minimal occupancy by the church, 16%. So that makes it quite different from certainly the situation in the DuPont Circle case, where the church was actually going to still operate substantial programs out of the building with the condominium. I don't think there's a single case, and then of course, as Judge McLeese pointed out, the variance was reversed in that case because of not meeting the exceptional conditions factor of the test. So to the extent that there was any implication in DuPont Circle that this sort of partnership might be allowed as a practical difficulties, the facts are extremely different here because the church's presence here is so minimal. The other point I just wanted to go back to is the whole question of the special exception and whether or not that this facility is a CCRC. And I do, want to point out that the BZA did not grapple with this issue at all. And so it's entitled to no deference whatsoever. On the question of, healthcare and, the questions that were raised earlier about whether healthcare services really should be part of this continuity of care. And I think the answer to that is that, if you recognize an independent living situation would not, which is a CCRC, would not need to provide healthcare services, but it would be limited to 8 residents. But if a CCRC provides a continuative care that includes independent living plus assisted living, then health, and so it's exceeding the 8 resident requirement, it must provide healthcare. Otherwise, this facility is no different from basically an elderly apartment building, of which there are many on Ward 3, where which are predominantly occupied by senior citizens, many of whom require extensive amenities and assistance with activities of daily living that are appropriately located in a high-density residential area and do not categorize themselves as a CCRC so that they can then, be built in a R1B low-density residential zone.
All right. Thank you, Ms. Förster. I'm sorry, were you?
Yes, thank you.
Okay, thank you very much. Mr. McDonald, I think we're giving you a minute or so for your closing. You're on mute, Mr. McDonald.
Yes, thank you, Chief Judge. Very quickly, Ms. Baum in her immediate response indicated her agreement with my paragraph 3 in my reply brief, where I mentioned the Nestor family supporting the effort, and went on to say in my reply brief, like 5 families. So essentially, 5 could become 0. The amount of support for this in the neighborhood is extremely limited. The other point I would make very quickly, being a 200-footer, being in a house diagonal from this proposed project, with all due respect, and I know the Chief Judge has raised this more than once, there has been no feeding of the poor or the hungry that I have ever observed there. They are operating, again, this is just me walking down our quiet block. There's typically no one in that building, the church. We all love churches, but this issue of what services they're providing now to the panel, especially to the Chief Judge's very relevant questions, I see no activities there. So thank you very much.
All right, thank you, Mr. McDonald, for participating today.
Thank you.
We thank all parties for your briefs and your arguments today, and we will take this matter under consideration. And that concludes the argument in this case, and you're each free to exit our virtual courtroom at this time. Thank you.
Thank you very much to the panel. Thank you very much.
Thank you, Your Honor. Thank you.
All right, good morning. Our second case this morning is Alonzo Jesse Atkins versus United States. Our counsel ready to proceed?
Yes, Your Honor.
Counsel for, I can't see the name, I'm sorry. Counsel, you can proceed. Thank you.
Thank you, Your Honor, and good morning, Your Honors. And may it please the court, Adrian Madsen on behalf of appellant Alonzo Atkins. I'd like to reserve 3 minutes for rebuttal. I'd like to begin by addressing the Confrontation Clause violation in this case. Prior to trial, the parties litigated the admissibility of 3 sets of out-of-court statements, 2 favorable to Mr. Atkins and 1 set unfavorable to him. The trial court correctly ruled that the first 2 sets of statements were admissible as substantive evidence under the excited utterance exception, and that the 3rd set was admissible only for impeachment and only if either of the first 2 sets of statements were put before the jury. Despite this clear ruling involving a fairly straightforward application of Sixth Amendment jurisprudence, the government elicited inadmissible hearsay, the third set of statements, during its case in chief. More specifically,
can I stop you there? Now, so I understand the government's arguments here. This was an admissible hearsay, and then the additional statements of Ms. Singletary at a later point in time after the 911 call were admitted only for impeachment purposes, and therefore were not testimonial in nature. How do you respond to that argument?
Your Honor, as the trial court ruled that those third set of statements that were made approximately an hour after the first two, that is the 911 call and the statements immediately following the 911 call, those were going to be admissible only if the first two sets of statements were put before the jury. At the time of the government's case in chief, neither of those first two sets of statements had been put before the jury. Those were played in Mr. Atkins' case, in the defense case. So in the
why do you say that the government introduced the third set of statements in its case in chief?
Your Honor, directing the court's attention to the November 15th transcript at page 30, there is a question that is, even though the question may have been phrased in a way designed to not elicit the inadmissible hearsay, the answer gave it. That is, without telling us the substance, the question was, without telling us the substance of the conversation, what happened after you talked to her? The her here being Ms. Singletary. The answer provided by the detective was, she took us to the location of the weapon, and here's the critical portion, that was used.
Where's the explicit hearsay in that?
That the weapon, that this is the weapon that was used to shoot Mr. Atkins.
Well,
that is,
the statement doesn't say that. Maybe it implies it, or maybe the officer knew that was the weapon that was used by the time of trial because the weapon was aware of the DNA results. We don't really know. So would you agree it's not explicitly hearsay? It doesn't say anything about directly, it doesn't explicitly say anything about what Ms. Singletary may or may not have said. Again, I know there's more evidence that comes in later, but just considering that comment, I'm missing the explicit hearsay.
Your Honor, the only, in my view, I understand Your Honor's point, but in my view, the only way that the detective at this point, when he is testifying about what happened at this stage, the only way he would have had knowledge of this purported fact is on a hearsay basis.
Well,
I'm sorry.
Why is that? I mean, he's talking at trial, so he's saying she took us to the location of the weapon that was used. Obviously, he thinks at the time of trial that was the weapon that was involved in the shooting, but he doesn't really say why. And it seems like he could have lots of reasons to believe that at the time of trial that we don't know.
Your Honor, I believe the next question that is asked and the answer is also strong evidence of what the detective was referring to. That is the next question on the same page, that is page 30 on November 15th. Okay, now when you say she took us, were you personally one of those officers? Answer, no. I walked into the alley with her, but it was Detective Evelyn and Officer Molina, suggesting very strongly that what the detective is testifying is about were his observations at the time, not his knowledge at the time of trial.
Let me just clarify to make sure I understand your argument. Are you saying that those statements couldn't have been used at all, even for impeachment? Or are you saying that they were being used for the truth of the matter asserted? And if so, if it was for the truth of the matter asserted, then I'm not sure I understand your response to Judge McLeese's question about who said it. Nobody, because it would have to be Ms. Singletary who said it, what the officer is repeating, isn't
Yes.
it? And here we don't have that you're asking us to infer that. Because there's not.
Yes, Your Honor, I am asking the court to infer that, and I'm asking the court to infer that from the later statements that do come in and the government's argument about them later, combined later with the court.
I ask you, with respect to whether we should or shouldn't infer it, it seems as though defense counsel didn't infer it, because there's no objection here that says, wait a minute, you ruled that the third set of statements can't come in, and this is an implicit end run around that ruling. And I think what's really happening here is that the government's violating your ruling. There's no objection like that, which tends to suggest that at trial the defense attorney didn't draw the inference that you're asking us to.
Which certainly is why the court is reviewing for plain error here, Your Honor, as acknowledged.
Since we're reviewing for plain error, and this is a little murky in my view, are there any cases on point that you can address us to? And if so, if not, how do you survive plain error?
Well, Your Honor, I'll note first that this is one component of the larger confrontation argument. That is, this is not the only statement that in the end was put before the jury for an improper purpose. That is, this is.
I understand that you have a sort of a multi-pronged approach on the confrontation clause issue, but on this particular point, if there is no previous clear case on point where similar inferences are made by the court in our position, would this particular argument survive plain error? Or are you looking to make a cumulative error argument?
Your Honor, as the court is aware, the impact is considered cumulative. So this is just chronologically the first that comes up, but by no means the only issue regarding the confrontation clause.
Any cases you want to point us to that are close on this issue?
I'd be happy to provide those to the court afterwards, but not here today, Your Honor.
Okay, thank you.
Certainly. So at this point, if the court accepts the inference that I'm asking the court to make, that testimony should have been stricken. Again, the first two sets of statements, the 911 call and the statements immediately following the 911 call, had not been put into evidence. And if they never came into evidence, then even for impeachment purposes, the third set of statements was not admissible, as the trial court had already ruled. That is, and then at the beginning of his case in chief, Mr. Atkins played those two sets of statements. That is, the 911 call and the statements made to responding officers immediately after the end of the 911 call. And in those statements, Ms. Singletary exculpated Mr. Atkins, if credited. Those were that there had been a robbery and that Mr. Atkins had been shot during the robbery. This was all consistent with the trial court's pretrial ruling. In its rebuttal case, the government certainly was permitted to.
You started chronologically and you skipped over one thing that happened in the sequence. I just want to make sure that's in the picture. So am I right that during defense cross in the government's case in chief, the defense counsel explicitly elicited some of the third set of statements on questions on cross?
Yes, Your Honor, after the prior colloquy that we were just discussing, yes.
And you think that's relevant to figuring out whether there is plain error or the like, if rather than objecting when at best, arguably implicitly, there was reference to those, the third set of statements during cross, the defense attorney, I mean, not just kind of inadvertently elicits it, but specifically says, you said that she said she took you out of the gun. That's correct. But did you ask her where the gun was? Yes. And what did she say? And kind of intentionally and explicitly is eliciting those. Do you agree that's an important set of events that might relate to whether we think there's reversible error here?
Your Honor, I had that come before the first colloquy that we're referring to. I believe that it would be more relevant. I will also note that there will be a forthcoming motion pursuant to DC Code 23110 in this case. But in terms of the issues before the court today, again, had the order been different, I believe that Your Honor's point would have been better taken. But with the evidence already having come in, again, the court may or may not accept the inference I'm asking the court to make, and as the jury may have done. But I don't believe that it seriously impacts the plain error analysis given that order, given that the defense was responding to the evidence that had already come in.
Mr. Madsen, can I direct you, unless you have further arguments on the confrontation clause point, to your prosecutorial misconduct and to the, I'm interested in your view on the Greer case, which the government submitted through a 28K letter.
Certainly, just briefly to take Your Honor's point regarding the confrontation clause, I would just add that if the jury followed the court's instructions, it could not consider the statements that were actually admissible as substantive evidence for their truth. That is the statements favorable to Mr. Atkins, and in fact would have to consider or could credit the testimony that was only available for impeachment, just in terms of evaluating the harm of the error. Your Honor referenced the prosecutorial misconduct and the Greer case, and I just want to make sure that, would Your Honor like me to address the prosecutorial misconduct first, or the Greer, which of course is related to a different issue?
Whichever order you prefer, counsel. Thank you.
Certainly, Your Honor. So in terms of the prosecutorial misconduct, which that is the prosecutor repeatedly commented personally on the evidence, and in fact, sort of dovetailing with the confrontation argument, was arguing statements known to be admissible only for impeachment for their truth. And of course, when considering the impropriety of the argument, that is, the court has a 4-factor test: the gravity of the improper comments, the relationship to the issue of guilt, the effect of any corrective action by the trial judge, and the strength of the government's case. And so taking those in reverse order, this was far from an overwhelming case for the government, with the evidence that was properly in evidence as substantive evidence. That is, there was no percipient witness who testified that Mr. Atkins possessed a weapon. There was DNA evidence where Mr. Atkins was one of 4 contributors, according to the government's expert. Both the government's expert and the defense DNA expert testified that could have occurred during a struggle, again consistent with the excited utterances that had already come in. In terms of the effect of any corrective action by the trial judge, there was none. That is, and regard with those that related to the confrontation clause error, that is, the purported or the attempts at corrective actions by the trial judge, in fact, reinforced the errors. The relationship to the issue of guilt, that is, to take some examples from the November 19th transcript, as an example, well, I'm telling you how the DNA got there. He had the gun. Miss Singletary said he had the gun in his hand. So many of these comments are going directly to the issue of guilt, that is, to the issue of possession, and the gravity of the comments. Again, there was fairly extensive pretrial litigation and discussion of this. The trial court took the time to say, here's a timeline of events. Okay, this one comes in, this one comes in, and this one only comes in for impeachment if these others come in. And so in terms of
these again are being reviewed under our plain error standard here, because there was no objection at the trial court.
Your Honor, there was an objection to one of the comments. I agree that largely the court is reviewing for plain error. That is, when Officer Epstein was testifying, there was an objection. That is, the jury had heard that Miss Singletary called 911 to report a burglary, and rather than limiting its question to the officer's observations, the government sought a legal conclusion, which prompted an objection. That is, the prosecutor asked, when you arrived at the scene, did it become apparent to you that it was not a burglary one? That is, the officer then testified, when you go to enough of these kinds of scenes, you tend to know when something like burglary happened. There's no signs of forced entry.
That one on the record, where are you reading from?
Your Honor, that is from November 15th at page 91, I believe beginning at line 12. So there was an objection to that comment, but I agree that largely the court is reviewing for plain error. And in terms of
Can I ask one other question, just for clarification? There's repeated discussion about a motion for mistrial, and I assume this is probably just a typo in the record, but in the transcript on November 11th of 2015 at page 92, I don't see the word motion or mistrial at all. And I also searched through the records and I don't see that language. It seems like there must have been a typo because there's no dispute that there was a motion for mistrial, I assume.
There is no dispute about that, Your Honor.
Okay.
Your Honor, turning to the, unless Your Honor's had further questions regarding the prosecutorial misconduct, I see that I am out of time, but would like to briefly address the Rahafe issue, if I may.
I would appreciate that.
And as Your Honor asked about the import of the Greer case, I think there are several important things to point out about the Greer case. First, that is that of course, the court's decision regarding the means by which appellate courts should consider the impact of Rahafe errors on plain error does not bind this court. Second, in the District of Columbia, there's a statute that is at issue that was not at issue in being considered in Greer regarding the proper use of pretrial services report. And frankly, it simply is somewhat inconsistent with this court's holdings regarding eschewing appellate fact finding. That is, to be frank, I think the Supreme Court got it wrong in Greer, but that's not. I understand that's not my position.
Right, but in Rahafe, the Supreme Court analysis is focused on the federal statute, and our DC statute is different on its face, and it doesn't include the language knowingly. Go ahead, I'm sorry.
It does not, Your Honor. However, as the court stated in Rahafe, and as this court has held in Correll, even where a statute is silent on the mens rea, this court, in order to avoid criminalizing innocent conduct, does require the scienter, and with that being at least knowingly, I think it's a.
Well, you're stating this as a flat rule. I thought that was more presumption that isn't a flat rule. I mean, are you saying that our law is that it's a flat requirement that any statute that has an element that distinguishes between lawful and unlawful conduct always has to be at least knowing?
I agree that there is not an explicit rule. I would phrase that as a very strong presumption, Your Honor, based on this court's decisions. So looking to the Rahafe issue, that is that as this court has done in prior cases, including Carroll, reading in the mens rea to avoid criminalizing otherwise innocent conduct, the court's brief indulgence, and this court has also found, if this court does find error, which for the reasons discussed in the brief, I would submit there are, that is, in terms of affecting the substantial rights, the more abstract, in terms of what record to review, going back to the Rear case, that is, the more abstract question of guilt or innocence is not the issue, which is why constraining to the trial record would be more appropriate. In terms of seriously affecting the fairness or the integrity or the public reputation of the proceedings, as this court has held in Malloy, an instruction omitting the mens rea element of the offense is an error of constitutional dimension. It goes to the essence of the crime charged and seriously affects the fairness and the integrity of the proceedings. And so I would ask for the reason.
Counsel, again, you then seem to be stating a per se rule that anytime an essential element is not instructed to the jury, it's not only like reversible error if objected to, but per se reversible error, even if not objected to, kind of per se plain error. But I thought we had followed along Supreme Court decisions in Nader and in Johnson in rejecting those kind of flat rules and instead having a case-specific inquiry into whether errors of that kind warrant reversal, either under a harmless error standard or under a plain error standard.
Yes, Your Honor, certainly. And this is not a per se rule, but given the evidence in this case in reviewing the whether there's a reasonable probability of a different outcome, I would submit that largely for the reasons discussed already regarding the confrontation error, that there is a reasonable probability of a different outcome, particularly if constrained to the trial record.
Well, if there is no per se rule under, how do you get past the plain error review here in order for us to find that rehafe is applicable to our DC statute? And that Green, which seems to, or Greer, I'm sorry, which seems to limit rehafe's applicability in a case like this, is not applicable.
Sure, Your Honor. And I think the difference is that going back to the principles of statutory interpretation that led to the court's decision in rehafe, again, that does not obligate the court to follow in evaluating the harm from errors, that does not obligate the court to follow Greer. That is.
But do you agree that we are equally not obligated to follow rehafe?
Yes. Yes, I would agree. That is, however, the principles that undergird the court's decision in rehafe, that is, again, they were not obligated to follow, but strongly counsel in favor of following the court's decision there.
All right.
Unless
anything further, Mr. Mattson?
No, Your Honor.
All right, thank you. And you reserved a couple minutes for rebuttal, I believe. Mr. McGovern? Mr. McGovern, you're on mute.
My apologies, Your Honor. May it please the court, Michael McGovern on behalf of the United States appellee in this matter. I'd like to begin with appellant's confrontation clause claim. Appellant concedes that his Sixth Amendment confrontation law claim is subject to plain error review. Because the record does not plainly or obviously show that Singletary's statements to Detective Moore were introduced for their truth, appellant's claim must fail. There are three reasons that appellant can't meet his burden to show that Singletary's statements to Detective Moore were introduced for their truth. First, the trial court explicitly instructed the jury that Ms. Singletary's prior inconsistent statements may not be used for their truth. And in particular,
it's funny you start with that, which seems to me maybe the most obvious mistake that was made in the trial. So explain to me why you think the instruction to the jury would have told the jury that Ms. Singletary's third set of statements couldn't be used for the truth?
I have two answers for that, Your Honor. The first, which we indicated in our brief, is that we believe that any argument that the instruction itself was ineffective at adequately communicating how it could be made was waived by appellant when he agreed to the modified instruction as it was provided to them in the written instructions.
I mean, that may be true. I'm not sure that's an answer to my question, which was you were asserting that the jury, don't worry, the jury was told that Ms. Singletary's statements couldn't be admitted for the truth. And my question was, let's talk about the substance of that instruction, how that would have communicated that to the jury. So that it might not be a freestanding basis for relief. I get that as a separate point, but focusing again on what the jury was told, how it could have understood what it was told. Do you have an answer about why the jury would have understood what it was told to preclude it from considering Ms. Singletary's third set of statements for the truth?
Yes, Your Honor. And I would direct Your Honor to the record document number 20 at pages 8 and 9. And that is the written instructions, which is the re-instruction that was given by the court. And particularly on page 9, they're discussing the use that may be made of an inconsistent statement. And in sentence 2, the court instructs the jury, it is for you to decide whether the witness made such a statement and whether in fact it was inconsistent with the witness's prior position. And so in that statement, the court is distinguishing between what is the inconsistent statement that the jury is evaluating, the statement made on an earlier occasion, with whether or not—
And just to be clear, what's the earlier occasion in that instruction?
Prior to trial.
Prior to trial, where's that in the instruction?
Your Honor, it's not explicitly stated, but the instruction states you have heard evidence that Mauricia Singletary made a statement on an earlier occasion, and that this
Actually,
statement.
there were 3 statements made on earlier occasions. If earlier is measured from the time of the instruction, then Ms. Singletary made 3 different sets of statements on earlier occasions, I guess, right?
Yes, Your Honor, and that is then qualified by the following clause, and that this statement may be inconsistent with statements referred to here at trial, referring to other of her statements.
I literally, if I were listening to it and I were a layperson, I would be very confused. But I guess I would be thinking, well, Ms. Singletary made 3 different sets of statements on an earlier occasions, and those statements may be inconsistent with other statements referred to at trial, all 3 of those. So now I have 3 sets of statements that might be inconsistent with any one of the other 3 sets of statements. And then there's this next sentence about it's for you to decide whether the witness made a statement and whether it was inconsistent to the witness's. I'm actually looking now, I'm not looking at the written instruction, I'm looking at one of the transcripts. So I gotta make sure I get the written instruction in front of me.
Yes, Your Honor, if I may, the difference between the instruction as given orally and the written instruction is that he said inconsistent with the witness's position, I believe orally, but in the written instruction, he clarified that to say inconsistent with the witness's prior position. And
prior position, meaning
the
prior then to trial.
So, Your Honor, the government believes that although
just before you tell me your general beliefs, you're referring to this language in the written instruction, which I do now have in front of me, that the jury had to decide whether there was a statement on an earlier occasion, which could be any one of the 3, and whether it was inconsistent with the witness's prior position. Do you think prior position means prior to trial, or prior to the statement among the 3 that the court is comparing, that the jury is comparing to other statements that are made thereafter? How would a reasonable juror have understood the phrase prior position in your view?
In my view, in the context of this trial, the way in which evidence came in and the order of Mrs. Singletary's statements and how they were introduced, the jury would have understood that the witness's prior position was the first position that she took to law enforcement, which was her 911 call, which was admitted by appellant.
The later instruction then starts pointing exactly opposite to what you're saying, because then it says, if you find an inconsistency, you may consider the earlier statement, which I think is her original statement to the police in what you're telling me prior position means, unless you think prior position means something different from earlier statement, in judging the credibility, but you may not consider it as evidence of what was said in the earlier statement was true.
Yes, Your Honor. So the earlier statement, as it's used in the 3rd sentence, I believe may be read in conjunction with the opening sentence of the instruction, which states, you have heard evidence that Mauricia Singletary made a statement on an earlier occasion. So here we're talking about the inconsistent statement that was made on an earlier occasion, which may be inconsistent with the prior position. We believe in the context.
To be clear, you think earlier occasion means, you think earlier occasion means something different from prior?
I'm totally confused. Which statement, can you just read through this instruction and tell, and insert 911 call, statement to detective at time X, statement to detective at time B? I mean, because I don't know how to read this, and it seems to me that earlier occasion shifts in the instruction.
Yes, Your Honor. As it would be read, it would be, you have heard evidence that Mauricia Singletary made statements to Detective Moore, and that this statement to Detective Moore may be inconsistent with statements referred to here at trial, her prior 911 call. It is for you to decide whether the witness made such a statement to Detective Moore.
Wait, which is such a statement?
Statement to Detective Moore. It is for you to decide whether the witness made such a statement to Detective Moore, and whether in fact it was inconsistent with the witness's prior position, her statements on the 911 call. If you find such an inconsistency, you may consider.
So, do you see, it's just to pause right there, right? I mean, the earlier occasion and the prior position now have been defined differently.
Correct, Your Honor.
Not just differently, but
that's confusing.
The one that is earlier is different from the one that is prior.
Certainly, Your Honor, I believe when that certainly the language is not a model of clarity, and
actually maybe a model of inclarity, if that's a word. I mean,
but again, in the context of how it came in, we believe that the jury would understand that it was trying to determine whether a statement was inconsistent with the prior position, being the 911 call, and if so,
well,
it was
in
only
figuring out. I mean, I understand your position on that. I will say I find it challenging. But if we're trying to figure out how a jury would have understood it, do you agree
Yes.
that we should consider that the jury might have been influenced by how the attorneys argued the use of the statements?
Yes, Your Honor, and those were the other two reasons.
That because your opponent argues that there are a number of circumstances in closing argument where the prosecutor, in referring to the last set of statements, and by last I mean chronologically last in the sequence in the real world, so the post-ruse statements, that the prosecutor in closing argument expressly asked the jury to believe them as true. I know you argue otherwise, but like with respect to the, could you just walk me through the why you think that's not true with respect to, for example, the statement about, she said he had the gun and that's the truth, which is a paraphrase, but can you walk me through that one, which seemed the hardest for you?
Yes, Your Honor. So certainly, as you indicated, when certain of the phrases that of the prosecutor's argument are taken out of context and viewed in alone, they at first appear to be problematic. But when the prosecutor's closing argument is viewed in its entirety and in context, the use of his statements, his use of Singletary statements to Detective Moore was in order to focus on its inconsistency with the 911 call rather than for the truth. With the exception of one instance, and based on my reading, I see 5 instances in which the prosecutor discusses Ms. Singletary's statements to Detective Moore. Of those 4 instances, each of them is tied explicitly to a discussion that challenges the credibility of the 911 call. Indeed, the first time that he introduces Ms. Singletary's statements, it's on page 61 of the November 19th transcript. And this is, the prosecutor argues, talking about the evidence that had come in from Detective Moore. He said he told Ms. Singletary he knew what happened, that the defendant shot himself in the foot, so just tell me the truth. And what did Ms. Singletary do? She just opened up and told a completely different story than what she said on the 911 call. So the import for which those statements are introduced.
But then problematically, he then references the instruction that we've just been talking about, which is impenetrable and possibly points the jury in the opposite direction and tells the jury, you're able to use that, whatever that is, to determine the veracity, the truth of that earlier statement. I mean, I'm not sure that this is the best example for the government as far as showing that the closing argument was correct or didn't harm Mr. Atkins.
Certainly. So he does point to the prior instruction, and in that defines the inconsistent statement as the statements Ms. Singletary, we believe, is defining the inconsistent statements that are covered by that instruction as the inconsistent statement that was given to Detective Moore by Ms. Singletary. And so when the jury understands that that is what is the inconsistent statement.
But I don't think the jury does understand. I mean, so let me just read this all the way through. He says, and what did Ms. Singletary do? She just opened up and told a completely different story than what she said on the 911 call. And we just heard the instruction about a prior inconsistent statement and that you're able to use that to determine the veracity, the truth of that earlier statement. And so we'll talk more about that subsequent inconsistent statement a little later, but the important part is she told the officer, and you'll have the tape to play back and listen back. It was a little low and her voice is low. You'll have to focus on it. But she said they got into an argument. He had a gun. It went off. She had the gun. I don't know what the inconsistent statement is or the prior statement or the earlier statement. I mean, if I'm a jury listening to all of this and I just got that incomprehensible instruction and then I hear this argument, I'm not sure what I'm supposed to be relying on for the truth.
Well, and again, Your Honor, it's not just the at this point that the statements from Ms. Singletary are referred to as the inconsistent statements, but it is defined by defense counsel himself. There doesn't seem to be any dispute, and defense counsel understands what is being referred to as the inconsistency. And this is at page 76. Defense counsel in his closing says the second piece that Mr. Thompson is hanging his hat with respect on behalf of the government is so-called Ms. Singletary inconsistent statement. You have a body cam with statement from her, but it's not complete, and I'm paraphrasing here, it doesn't complete what Detective Moore may have told her.
But I get that line of thought, but to me, the biggest obstacle to you is the one you haven't confronted yet, which is the passage in rebuttal closing on page 83, where the prosecutor circles back around to the statement after the ruse and says, the officers came back and tricked the girlfriend and told her, look, he told us what happened. She was like, okay, well, now I can tell them because they already know what's going on. And she told them the truth.
Yes, Your Honor.
I just don't know what context you could add to that other than that's telling the jury, here is her, statement that's being admitted only for impeachment. I mean, that's not what is being said to the jury, but that is the statement as to which that's true. And the prosecutor refers to it and says, that was the truth.
Yes,
I mean, that's just like an indisputably impermissible use of that statement.
So again, when viewed without reading it in context, it may appear problematic, but I would ask Your Honor to continue.
I mean, I understand your desire to waffle a little bit, but can you explain to me how out of context it could be viewed as permissible? Just consider it in isolation and say, how could it be viewed as permissible? Could you explain how you would defend that proposition as even arguable?
If he simply stated out of context, and she told them the truth, whether that would be defensible, is that what I understand Your Honor to be asking me?
What you said, I'm just asking how you defend one thing that you said, which was you said, considered in isolation, this might be viewed as an impermissible use. And I'm just asking, is there any possible argument that it isn't an impermissible use considered in isolation? That's my question. What would that argument look like? How would you say, no, that's fine? And just looking at those three sentences, here's my why it's arguably okay. I can't quite imagine what that argument would look like.
Because, Your Honor, they state, and she told them the truth. It doesn't indicate that because she said it. And so that's part of what is missing here. But even if viewed in isolation, that is what Eric would call
I think
viciously.
that is the quintessential offering a statement for the truth of the matter asserted on its face. I think that's what Judge McLeese is saying, but you want to say, let's go to the context. And if you put it in context, when he said, and she told them the truth, he didn't really need to tell the jury, rely on this statement for its truth. I'm trying to look at the context. This is the government kind of summing up its case and saying, I'm going to conclude the government's proved its case. We've got DNA. We've got, the fact that the girlfriend told you the truth, that he shot himself in the foot. And I'll go over it one last time. There was no break-in. There was nothing taken. There was no burglary. He just shot himself in the foot. I'm not sure how that context helps you either.
Well, Your Honor, it would be the sentence that follows it, which is, and she told the truth and the evidence that's with it supports it. I'll go over that one last time. So here, he is stating she told the truth. The government is required under its theory of the case.
That's not the question.
In
Sorry, go ahead.
To say there's corroborating evidence, she told you the truth, and I can corroborate that. I don't see how pointing to corroborative evidence points against use for the truth or suggests limitation to impeachment. It seems to me the way if you say, here's some evidence for the truth, and there's lots of other corroborating evidence, that's a truth use. So I'm not quite sure why pointing to corroborative evidence is helpful context.
So, Your Honor, I would then point to the context of the entirety of the prosecutor's argument, and multiple times throughout his argument, he made the distinction between why the possession of the gun was being based on evidence, which he contrasts with those statements. And so I'll point to page 80, where the prosecutor is arguing there's no evidence to support the burglary. I'm not asking you to believe this statement, the statement being Singletary's statement in Exhibit 99, just because the statement was made. No, I'm asking you to believe it because of the facts that support it and the facts that don't support that 911 call. So the prosecutor has already set up in his argument a distinction between whether one should consider the statement for the truth of the possession or whether it should be considering that statement as he uses it in every other time to contrast the statements on the 911 call.
That explicit use seems to me incorrect also. The prosecutor shouldn't be saying, I'm asking you to believe it. If you're really being, I mean, it's hard for juries to do this, for sure, and then that's but the prosecutor, I don't think, should be saying, I'm asking you to believe this statement. That's just wrong-headed from the start. Shouldn't the prosecutor be saying, I'm asking you to use this statement to consider whether to believe the earlier contrary statements, and I'm asking you, because of this statement, to disbelieve those. Isn't that the impeachment use, and isn't saying I'm asking you to believe the statement itself additionally unhelpful context?
So, Your Honor, I do believe that the prosecutor has to ride this very fine line in this case, which is that the subject of his argument is the substance of her statement. The government's theory of the case is to prove the fact that he held the gun, and the very statements that she made were that he held the gun. So it is in a position where it must make an argument that those statements are true
No, I don't think that's right. I think it needs to make it, the argument it needs to make logically implies that the statement is true. I don't think it needs to expressly assert that the statement is true and can be believed as direct evidence of its own truth.
I understand your Honor's concern, and but this is would point that that the way in which the prosecutor, if you view the arguments in their totality, was attempting to use this statement. Although in these individual instances, it may appear that he's using it expressly for its truth, that the overall impression the jury would have had, given the totality of his argument and the manner in which he used them, were to impeach the veracity of the 911 call.
Mr. McGovern, you seem to be suggesting that essentially, even if these statements amounted to prosecutorial misconduct, that there was no prejudice because of the totality of the circumstances. Is that what I hear you saying?
I do believe that this argument does go to the question of prejudice as well, Your Honor.
Can you talk about why, if we were to conclude that the statements were ones that we have previously found would amount to prosecutorial misconduct, how prejudice prong would save this?
Well, I think you have the fact that the materiality of referring to the truth of the matter statement, it can be assumed that it's not that material because you have no objections here from the defense counsel. And in a case where it was explicitly discussed that the proper use of these statements was only for impeachment purposes, you don't have the judge sua sponte intervening.
That's why we're applying plain error. I mean, I think the question is, why is this prejudicial or not, right? And so I thought you were going to answer the Chief's question by pointing to the other evidence in the case.
Well, respectfully, Your Honor, I do think you can consider the absence of the objection. And here I think it's more than just an absence of objection. It's an absence of objection.
Why isn't that double counting? I mean, that's what puts us in the plain error framework, right? So now here we are. And we're trying to figure out if this affects Mr. Atkins' substantial rights. And I sounds like the government is resisting doing sort of the normal affecting substantial rights analysis.
Were you finished on the prejudice piece, Mr. McGovern? I'm not sure I got your argument as to why there was no prejudice in the government's view.
No, Your Honor, thank you. Aside from whether or not defense counsel made an objection, or we also believe that the thrust of the prosecutor's arguments, as we've been discussing, and the primary uses and the material uses that he made of those statements were as inconsistent as statements that were inconsistent with the 911 bearing on its credibility. And also that he repeatedly throughout the argument points to the DNA evidence and the falsity of her burglary story as pointing to the appellant's possession, so that the pillars of the prosecution's argument on his possession were in fact not the truth of this matter stated, but on the physical evidence and the improbability of the story that she told to the 911 operator. And we would also note that even if there was prejudice, this court still has to determine whether or not, in the interest of fairness, this conviction needs to be reversed. And here, as Judge McLeese was discussing with appellant's counsel earlier, there is the issue that it was in fact appellant's counsel who first introduced, and I'm setting aside for now a discussion of the page 30 issue, which was the beginning of appellant's argument. But absent page 30, which we don't believe is appropriately considered hearsay, the first instance that any of Ms. Singletary's statements were introduced was on the direct questioning on cross-examination by appellant's counsel. And appellant's counsel then marshals those answers during his closing argument and makes strategic use of that hearsay, and had it been elicited by the government's Sixth Amendment confrontation, or statements that would have been problematic in light of the confrontation clause. And so you have here appellant actually inducing and being the first to ask questions about what he now claims are problematic statements, marshaling that in his closing, failing to object at any time throughout the closing argument for uses of those statements that he now claims is problematic, and agreeing to an instruction which this court is agreeing to an instruction where the instruction that the trial court made explicit that the reason he was crafting this instruction was because it was a difficult issue to tie prior inconsistent statements.
Are we still on prejudice or further reasons for prejudice, or are you now addressing one of the other prongs, Mr. McGovern? I'm sorry.
I was trying to marshal these arguments in terms of prong 4, whether or not, even if you found that it was prejudicial, it would impugn the fairness or integrity of the trial to overturn here.
So Mr. Madsen mentioned that there's a 23-110 either has been filed or is about to be filed. Is this an argument for holding this appeal for that litigation then?
Your Honor, I don't know that I have an answer for what would be most appropriate in that circumstance. But certainly we would assert that there is no grounds on the current claims to reverse the conviction, and therefore ask that they not be reversed on the confrontation clause issue. Unless the court has any further questions on the confrontation clause or would like me to address the issue at page 30, I can move on to Rahafe.
Okay.
Thank you. Your Honor, as appellant acknowledges, the claim that it was error not to apply Rahafe is subject here to plain error. And because he has failed to advance any argument or evidence that he did not, in fact, know that he was a felon when he possessed a gun, under the Supreme Court's recent decision in Greer, his claim fails the third prong of plain error review, which would require him to show that his rights were substantially prejudiced.
Can I get clarification from where the government is right now on whether the government thinks there is a mens rea element, but that they can't show prejudice, that it affected Mr. Atkins' substantial rights by not instructing the jury? Or does the government think that there isn't a mens rea element in our statute because our statute doesn't track the federal statute? And if it's the latter, how does our decision in Carroll impact that argument?
Yes, Your Honor. So I would note that it's the government's position that the first and second prongs, whether there was error and whether that error was plain, need not be decided in this particular case, given the strength of the third and fourth prongs, that appellant has not been able to come in here to show plain error. And so the questions of statutory interpretation need not be reached in order to reach this particular court. We also would note that we believe it's unlikely this question may come before the court again. There is in the Red Book, in the 2020 version of the jury instructions, now a proposed fourth element, which would require proof in a felon in possession case of knowledge of a felon's status. And in prosecutions for felon in possession, the government is asking in an abundance of caution and prophylactically for that to be included. So we think it's unlikely that those issues will come before this court. So it's the government's position that the court need not address prongs 1 and 2. As a legal matter, if Your Honor is still interested, I'm happy to address that further. In other words, as a legal...
In what the bottom line position is.
Yes, Your Honor. So the government believes that Rahafe does not apply to the district statute. As Judge McLeese noted during appellant's argument, the statutory presumption that was relied upon in Rahafe and also in this court's opinion in Carroll is just that, a presumption of statutory construction that mens rea will apply to each material element. But that statutory presumption doesn't survive in the absence. There is a legislative history that indicates that there was no intent to have a mens rea for this element. And we believe that the legislative history, the differences, well, first I would note that Rahafe itself does not need to apply because the actual statutory language is different. In Rahafe, the federal statute had an explicit mens rea written into it, and the question that was being presented to the Supreme Court in Rahafe was whether that mens rea should apply to all of the elements as that statute was written. And they noted that when they imported the mens rea, which was included in the penalty provision, into what I'll call the prohibition section, that the statutory language, because the status of being a felon element appeared before the possessory element or the action of possessing a gun, it would make no sense to have the mens rea jump over the status and only affect the possessory element. Here we do not have that. First of all, there is no explicit mens rea in the DC's felon in possession statute. Secondly, the drafting of that statute shows that the possessory element comes before the status element, and if one were to import a knowing mens rea element into it, it would most naturally be read that one must knowingly possess a gun and be a felon. And so knowingly would not necessarily modify that. In addition, the legislative history shows that the Congress who initially enacted the statute, in 1953, when it enacted the statute, knew how to add a mens rea element to the status element. There was an additional crime that was defined in the same section, which was to knowingly hold a gun or firearm for another individual who had been convicted of a felony. And in that provision, it's explicitly stated that there would be, that the government would have to prove that the individual holding that gun knew that the individual they were holding it for was a felon. So the Congress was in that statute writing a mens rea requirement for the status element, and then chose not to do that in the felon in possession statute itself. So we believe that there's legislative history here that shows that the mens rea element need not be applied to the status element. In addition to that, the history of gun regulation and this court's interpretation of gun regulation indicates that other than possession, it hasn't typically been, other elements have not typically been viewed as needing a mens rea. So in the CPW carrying a pistol without a license statute, or the possession of an unregistered firearm statute, it is not necessary to know that the gun is not licensed, and it is not necessary to know that the gun is not registered in order to violate those. And it has noted that in the cases of dangerous and deleterious devices, it is not uncommon for there not to be mens rea elements as to certain of a mens rea applied to certain of the elements. And so in view of all of that authority, we do believe that rehafe does not necessarily apply to the district's felon in possession statute.
So in analyzing this for our case under plain error, would you rely on which prong of the plain error?
Well, Your Honor, we would argue that there is no error because mens rea doesn't apply. But even if there were a mens rea requirement, it's certainly, given all of the distinctions that I just spoke of and the complexity of the legal analysis to determine that, and in light of the fact that the mens rea has never been attributed to the status element previously, that it's certainly not plain that a mens rea would have been required. So we believe that his claim fails on all four prongs, that it is neither error, nor even if it were error, it was not plain. But most importantly, again, for the purposes of this court's decision in this case, appellant here has not come forward with any evidence that he was unaware of his status as a felon. And in fact, the record contains multiple pieces of information that indicate that he would have been aware of that status. Not only did
you want to address, with respect to those multiple locations where you might find that in the record, do you want to address your opponent's argument that the one that you referred to in your brief, which was a pretrial services agency report, is not properly considered for that purpose? Do you agree that that's true and that we would have to look elsewhere for that information, or do you dispute his claim on that point?
I don't, Your Honor. The specific provision that he cited to did indicate that there are permissible uses of the pretrial services report and that it could not be used as substantive evidence. And this is a case where the Court of Appeals is considering whether or not there is plain error. It's not looking to prove the elements of the crime here. It's simply looking to see whether or not there's any reason to believe that there would be a different result. And so the government is not using that information in a way that is antithetical to the particular statute that he cites. But in addition to that, it was that particular pretrial services report is not the only indication in the record. There is, it does appear in the pre-sentence report. The government did not cite that in its brief, but I will note that the pre-sentence report is a part of this record and could be considered by this court. And additionally, what Greer found, I'm sorry, Judge Easterly, did you have a question?
You're on mute, Judge Easterly.
So sorry. Thank you for taking note of me. You mentioned something about how he knew his status, and I just want to make sure that I understand what you are referring to with respect to status. By status, do you mean he knew that he had a prior felony, or he knew that by virtue of being a convicted felon, he could not carry a gun under the statute? The language of rehafe makes it sound like it's actually that you need to know, you have to knowingly violate the statute. So you have to know that because you are one of these enumerated people, you can't carry a gun. Just wanted to get the government's clarification on that.
So, Your Honor, what I will note is that the Red Book instruction that is being given is that one must prove that at the time the defendant possessed the firearm, he knew that he had been convicted of a crime punishable by imprisonment for a term. So it's knowing of the status, not knowing of the regulation. And I would note that that's in keeping with, again, that's
the proposed instruction, or sorry, what were you just reading to us?
That is the instruction that appears in the Red Book, the 2020 version, most recent version of the Red Book as a bracketed potential language for courts should they find that
Okay, but I'm asking what the government's position is as far as what if there were a mens rea or requirement vis-a-vis status, what does the defendant need to have knowledge of?
Of the fact that he had been convicted, that he was a felon, of his status itself, not of the fact.
And is it imprecise to say he was a felon, because that's a legal term? The Red Book instruction that you were referring to requires knowledge of receipt of a sentence over a particular length.
The precise term would be knowledge that he was convicted of a crime punishable by more than 1 year. Correct.
And most typically,
and
that's most easily proved by pointing to the sentence actually imposed, which usually is the most straightforward way of establishing that. But you know, you're putting a lot of weight on a Red Book instruction, and we've said a number of times that the Red Book is neither the law nor necessarily a correct statement thereof. So I'm not sure if you're asking us to defer or accept the accuracy of what's in the proposed Red Book instruction. That's probably not what our cases tell us we should be doing.
Apologies, Your Honor. I didn't mean to imply that it had authority in that way. But what I would note is that the question of whether the knowledge would apply to the fact that they were an individual convicted of a crime punishable by more than 1 year, as opposed to knowledge of the fact that there was a prohibition on those types of individuals to carry guns, would come from, again, pointing to those of opinions in the carrying a pistol without a license or unlawful possession of an unregistered firearm, where it is not the knowledge of the regulatory scheme that's necessary in order to make those crimes. And here would be the same, but that it's just proving knowledge of the fact that they were within the class of those who are prohibited, because, as those decisions have indicated, when an individual possesses dangerous or deleterious devices, the onus is now on them to determine what the regulatory schemes of possessing those are. And so the crime itself does not concern itself with the knowledge. And I'll just once again indicate that this is an issue that the government doesn't believe needs to be reached in this particular case. It doesn't believe that the knowledge requirement applies either to the status element of being a felon or to the question of whether an individual knows that there is a regulation that prohibits individuals that are felons, as a term of art, from possessing guns.
All right, thank you. Anything further, counsel?
If Your Honors have no more questions, we would respectfully ask that the convictions be affirmed.
All right, thank you. Mr. Madsen, you reserved a couple of minutes for rebuttal.
Thank you, Your Honor. I'd just like to address briefly a few points raised in the government's argument. The first regarding the confrontation issue. Of course, as the court has already heard, Mr. Atkins disagrees with the proposition that the inadmissible hearsay was first elicited by his counsel. The second is that in an attempt to, I believe that the government's words to contextualize what the statements in closing that the court, I think, rightfully had serious difficulty with and squaring how they could be put in any sort of proper context. But in making those arguments, the government has represented that a statement that the prosecutor's statement that there was no evidence to support the burglary should somehow remedy or contextualize these statements. But of course, there was evidence that to support the burglary. That was the entire point of the pretrial litigation. That is the testimony, the excited utterances that were coming in as substantive evidence. There was absolutely evidence to support the burglary. While there was circumstantial evidence that might cut the other way, there was no direct evidence, properly in evidence that would support the burglary.
Can I ask you, Mr. Madsen, if you could use some of your rebuttal time to respond to the government's argument about why there's no substantial prejudice, even if there some of the statements did amount to prosecutorial misconduct?
Your Honor, in doing so, of course, the court considers the strength of the evidence and the case, and that is, again, this was very far from an overwhelming case from the government. That is that there.
Well, but there was some DNA found on the firearm. There was the blood stain found in the rear of the apartment. So there is some evidence that could arguably be deemed to be substantial evidence.
Your Honor, as to the DNA, the testimony of the government's expert was that there was a mixture containing DNA from 4 people, one of whom the court, well, properly phrased, I suppose, that the odds of the mixture containing DNA from 4 unrelated people as opposed to containing DNA from Mr. Atkins and 3 other people were very high. However, the defense theory of the case and what was in as substantive evidence was that there had been a struggle over the gun. And of course, so in evaluating the strength and the import of the DNA evidence, I think it's very important to keep that in mind. And again,
another aspect of the government's argument on that point is really the reason that the defense wasn't objecting to any of this, this is paraphrasing, but this is what I take them to be saying, is that the reason the defense wasn't objecting to any of this, in fact, elicited some of it in detail, was because the defense had a kind of a plan B defense theory strategically, which was, the theory of the government that Ms. Singletary took the gun and put it back in the alley. The defense wanted to get that out and wanted the jury to be kind of thinking about that as possibly, as a theory that could possibly be true, because the defense wanted to be able to say, yeah, but that doesn't make sense either, because if that was the story, Ms. Singletary's DNA, she'd be among the mixture, and she wasn't, so that doesn't compute. So the part of the government's argument about no effect on substantial rights and no manifest injustice for purposes of the plain error standard is that really these things that seem to be going wrong fit into a defense strategy, and that's why there weren't objections. What's your response to that?
Your Honor, my response to that is that I don't believe those were part of a strategy. I believe those were, given some of the other facts in the case and the actions taken and not taken by Mr. Atkins' trial counsel, that this is an issue of ineffectiveness. That's the best response that I am able to give to that. And as an example of the ineffectiveness, Your Honor, unrelated to this, but just sort of going to whether there was a strategy or not, as the government concedes, there was an illegal sentence imposed with respect to count 2, the possession of an unregistered firearm, plainly an illegal sentence without the enhancement. And so just in terms of whether there was a coherent strategy there, I can't say much more than that. The government, in discussing if I can move briefly to the Rahafe issue, the government has repeatedly emphasized the idea that Mr. Atkins has failed to advance any evidence that he was unaware of the convictions. And this, I think, is a practical difficulty here, but that would, of course, be extra record assertions, right? The evidence that the government is relying on to suggest that inferentially Mr. Atkins had knowledge of his status was various ways to attempt to establish that Mr. Atkins had the convictions, but none of that says anything about his knowledge of the status. That is just a fact of conviction.
Well, it wouldn't have to be extra record. It would normally be extra trial record if nobody thought this was an element, and so no one was introducing evidence on it. But if you're talking about trial record in front of the jury, but in terms of whether the record in a particular case might shed light on it, it could shed light in either direction. It could be, as the government argues this case is, that your client was convicted of an offense, armed robbery, that people realized is a serious offense, and had a sentence that was over a year. And so unless he forgot, or unless those records are inaccurate, you would tend to think wouldn't be a very strong defense. On the other hand, you could have cases where the offense at issue was some offense that isn't well known, and the sentence that was imposed was 60 days. And the only thing, you could look in a statute book and you could find out that it carried a sentence of over a year, but the record would kind of suggest, well, you have good reason to wonder whether the defendant would have known. So it seems like it wouldn't always be extra record of the trial proceedings as a whole that a defendant could point to and make some arguments about why there's real reason to doubt whether my client would or wouldn't have known that the defendant had a prior conviction for an offense that was punishable by more than a year of imprisonment.
I certainly take Your Honor's point. My point is that the government has emphasized that Mr. Atkins has not produced an argument that he did not know, which I take Your Honor's point, and it's absolutely valid. However, that there are other ways that Mr. Atkins could not have known about these convictions, even assuming their existence, and that those would necessarily depend on where he did not testify in this case. Those would necessarily depend on an assertion that wouldn't be in the record to begin with. So if there are no further questions, I would ask that the judgment of the trial court be reversed. Thank you.
All right, thank you. We'd like to thank both counsel for your brief and arguments in this case, and we will take the matter under advisement. Thank you. And you can feel free to exit the virtual courtroom. And I would ask the courtroom clerk if we could take a short 2-minute break before we call the third case.
Thank you.
All right, good afternoon, and welcome to the virtual oral arguments here at the District of Columbia Court of Appeals. Our third and final case today is Conchita Plater, I hope I'm pronouncing that correctly, versus Michael Fisher et al. Could counsel identify yourselves and describe how you plan to divide the time today?
Good afternoon, Your Honor. I'm John Presley, and I continue for the appellant, and I'd like to reserve 4 minutes.
Okay, and then remaining counsel, could you identify yourselves and tell me how you plan to use the argument time today?
Good afternoon to the panel. This is Nathan Brazee for appellees for all the appellees except 5038 Street LLC and Classic Cottages LLC. I intend to use 13 minutes of time and will reserve 2 minutes of time for the remaining appellees.
All right, and the two remaining counsel, could you identify yourselves and your interests, please?
Morning, Your Honor. Brian Gallagher for 5030 8th Street, and we defer our time to Mr. Bressie.
Okay.
Good morning, Your Honors. Ashley Wiggins on behalf of Classic Cottages LLC. I also defer my time to Mr. Bressie, and I apologize for not having the proper background on it. It was corrected yesterday, and for some reason it's not coming on today. Okay,
no problem. So does that mean that neither Mr. Gallagher nor Ms. Wiggins intend to use any of the time for oral argument? You do want to use the 2 minutes, or you do not?
Your Honor, we will reserve the 2 minutes, but I do not anticipate actually having anything to say.
Okay.
The same for Classic Cottages.
Okay. All right. Thank you for that clarification. And so, Mr. Presley.
Thank you, Your Honor. Good afternoon to the panel, and may it please the court. I'm here on behalf of the appellant, Conchita Plater. Your Honor, there are a number of issues in this case that we've dealt with at the trial level and are now before the Court of Appeals. I'd like to start off by just basically summarizing how I see the overall perspective from a less specific or minor focus. Number one, there has been a lot of focus at the trial level as to whether or not the power of attorney was valid or whether or not it was forged. I think the big picture is that even if the power of attorney was valid, legal, there are still problems with respect to the alleged legality of the conveyance from Aquarius Enterprises, LLC. Specifically, there's no evidence to the effect that Aquarius Enterprises, LLC,
Mr.
ever
Presley,
owned the property in the first place.
I'm sorry to interject, but I was hoping we could back up just a little bit. The trial court determined to bifurcate the proceedings at the trial court to first reach the issue of whether or not there was a forgery on the conveyance documents. And because the trial court deemed that to be dispositive of all the other questions. And as I understand it, there was no objection to that on the part of the appellant at trial, to the bifurcation in order to determine whether or not there was a forgery on the power of attorney.
Well, Your Honor, yes and no to that question. I mean, we did not, frankly, oppose the bifurcation. The problem arose with respect to how it was bifurcated. If one looks at the record in this case, at the pretrial, there was a discussion and so forth with respect to the contours of the bifurcation. I made it very clear at that time, and I think that it's indicated at in volume 1. I can show you, Your Honor. Indulgence for a second. Okay, yes, here it is. Volume 1, pages 17 and 18 and 20. And in brief, what I indicated at that time was that there's still an issue. I indicated specifically that there's still the issue of this, excuse the expression, bogus Aquarius Enterprises. The fact that the property was not even conveyed to them and so forth is an issue. And I suppose that that's part of showing that this whole thing was, you know, a forgery and fraudulent and so forth. I go on to mention my concern about making sure that any bifurcation, was not simply related to a single document. And I emphasize that in those pages at the pretrial. Let me say just briefly also, Your Honor, that
I want to clarify one thing. Were you just reading from something in the pretrial statement, or were you now summarizing the exchange that occurred in open court on the hearing about whether to bifurcate? Because I thought you were originally going to be talking about what was in the written pretrial statement. Then it sounded like you were more talking about what happened in open court at the bifurcation hearing. So I just wanted to clarify. I want to make sure I know what you're talking about.
Oh, yes, Your Honor. I was talking about the discussion that took place regarding the bifurcation at the pretrial. And as I indicated, I made it very clear that how I felt about the bifurcation, if it was done properly and so forth. I should also mention that the motion to bifurcate by the defendants and so forth did not limit the bifurcation to a simple issue of whether or not there was a forgery or not.
Well, let me
And
ask you, let me focus on, in particular, Joint Appendix 2, pages 16 and 17, because there is a somewhat unclear discussion that goes on. But there comes a time when the trial court at the bottom of page JA2 16 says, if I were to conclude that she signed these documents, you know, the POA, and authorized, you know, in the power of attorney, then that's the end of your affirmative case, I think. And then you say, well, and the court says, which is quiet title and declares judgment and so forth. And Mr. Presley says, well, I have to say you have a point. I mean, and then there is, which seems to suggest that you, at least at that moment, were agreeing with the trial court's view that consistent with the way the complaint was written, though not so much consistent with the written pretrial statement, it was all about the power of attorney being forged. And all of these other circumstances were kind of evidence. They were relevant, and you could prove them up at the trial. They were possible parts of proving that the power of attorney was forged, but that you weren't really saying, no, wait a minute, trial court, it's not just that they're relevant to my point in the complaint. I've got a whole new theory of, I've got independent theories, which is even if the power of attorney was valid, there were formal defects. I see Mr. Presley, there we go.
Oh.
There were formal defects in the deed that mean that the deed was invalid for other reasons. So what's your response to what the trial court, I think, ultimately viewed as what had happened at this court hearing about bifurcation, which was that you acquiesced in the only issue to be tried was going to be what was in the complaint, which is the forgery of the POA, and that the rest of it was all simply relevant information about that. And if you lost that, then your case was over.
No, Your Honor, I would say a couple of things. First of all, what I read indicating that my concern about the scope of the trial and so forth, and the scope of the bifurcation is indicated. Now, what you just indicated, with all due respect, was cherry picked and so forth. It eliminated the prior discussion and so forth, where I made it clear that my concern was that we would have a full trial basically on the issues and so forth, and not
actually, counsel, I think Judge McLeese was quoting from page 16. You were referring to page, I think, 17 and 18, where you said, I really would like to get into this other business about the special partnership or the general partnership, right? And how this property changed hands. But then on page 20, the court says, well, I think my instinct there again is to say, let's keep these things separate. Let's try the forgery case and the Simon Steele caper that Mr. Presley has alleged and see how that, he's saying, and that. So you're saying
Right.
That's where the court is agreeing with you that will play out that way.
Well, he was just agreeing with what I indicated. Like, for instance, on page 18, I say specifically, this whole thing is not
Well,
just
it's
a single
unclear.
discrete.
I mean, he says, and the Simon Steele caper that Mr. Presley has alleged, and see how that plays out, and then we'll decide what to do next.
Right, he indicates there, and the Simon Steele caper. That's how he sort of summarized what I was talking about previously, and that's what I'm saying. If you merely look at what I said specifically, quote unquote, on page 18, this whole thing is not just a single discrete thing. It was part of a broader fraudulent type of activity. And as I said, part of that is like right before your eyes. The fact that this Aquarius Enterprises general partnership never had title to the property. It never got title to the property. So basically, not to, give all the testimony, but all of that was said and so forth. And I made it clear that that was my position. Now, the judge, as you indicated, summarized that as the Simon Steele caper that Mr. Presley has alleged. So, and now let me point out also that's very important, and that is if you look at the motion itself, here's what the motion to bifurcate says, that on page 85 of volume 1, JA 85, it says in paragraph number 5, the issue of whether and to what extent defendants may be entitled to an equitable lien on the property is only relevant if Ms. Plater can establish by clear and convincing evidence that the December 5th power of attorney was a forgery, or can otherwise establish that Conchita Plater holds some legal or equitable interest in the property. Now, they made very clear that on paragraph 8, it says bifurcation of the forgery and equitable lien issues. Now, so in other words, everything except the equitable lien and so forth was part of what they're saying was the forgery. It's part of the other thing. It's either part of the equitable lien or it's everything else. They
Right,
don't say.
And I take your point that we have to put all this in context, but did you agree that another important piece of that context is what was actually alleged in the complaint?
But I also mention, Your Honor, there are 2 counts in the complaint. Granted, in count 2, there's mention of the forgery. In count 1 for declaratory judgment, there's no mention of forgery. It basically indicates that we want a determination of Ms. Plater's rights. That's not limited only to the forgery. That is, and I don't think that the trial court fully recognized that. They acted like there was only 1 count and so forth. And also, I don't see how it's reasonable or proper to ignore the pretrial.
You decide the 2 counts, but does the second amended complaint have facts in it that relate to the other additional problems with the deed that you later identify, including that the deed at issue purports to be from Aquarius General Partnership, but the actual legal title owner either was Ms. Plater herself or her sole proprietorship, which may have a slightly different name. Is that alleged factually in the complaint?
Indulgence here. Oh, yes, it says paragraph 16, Conchita Plater, however, was not aware of the purported conveyance and had never given defendant Steele permission or authority to act as her attorney in fact or convey any document.
Counsel, I think that's the power of attorney point, not the wrong grantor on the deed point.
Well, let me mention count 1, the declaratory judgment, which basically says that an actual controversy has arisen and now exists between the plaintiff and the defendants concerning their respective rights to the subject property, and that plaintiff contends that she owns the property free and clear of any express or implied trust interest claimed by defendants, while defendants contend that they hold legal and equitable interest in their property. A judicial determination of the rights and responsibilities of the parties over the subject real estate property in question is necessary and appropriate at this time. I think, Your Honor, that at the early stage of the litigation and so forth, there might be a general statement of concerns. I think that it's totally wrong to just focus on what a complaint says at the initial point. I mean, there's bound to be further discovery, things that you learn and so forth that clarify things. There were a lot of things involved in this case, let me tell you. And if you look at very clearly at the pretrial statement that was incorporated into the pretrial order, it clearly states all of my issues and so forth. That's something that has been clear all along. It was dealt with in the motion for summary judgment. It was in the case all along. So that's nothing that was surprising and so forth to anyone. That was clearly understood and argued at every part of the case.
Can I ask you, we focused on a procedural aspect of that, and I know we haven't really, one of your arguments is to challenge the trial court's ruling at the end of the trial proceeding about whether the power of attorney was or was not forged. But can I, on the merits of these separate points, can you just give me a quick basic understanding of what your response is to your opponent's set of arguments? The gist of them seems to be the following, which is if the power of attorney is valid, then your client authorized Mr. Steele to sell the property. Whatever the problems are with the deed, maybe, you know, it has the wrong grantor written on it. You know, maybe she never conveyed the property to the general to the general partnership and the like. But how is your client well situated to complain about any of those technical deficiencies if in substance your client said, yes, please go ahead and sell my property to those people? That's the gist of a set of their merits points. And I'm just interested in kind of what your general response is to take that form.
The only problem with that is that is not true. That is not factually the case. She never specifically, contrary to what is indicated by the defendants, she never, if you look at the power of attorney, which is on page 174 of volume 1, there is no mention of Classic Cottages. There is nothing that indicated that she directed them to sell the property to Classic Cottages. That never occurred. And another thing, let me throw.
If the power of attorney authorized Mr. Steele to, on her behalf, sell the property, her interest in the property at issue, and if that's a valid power of attorney, then whether she knew about the sale or not, she'd executed a power of attorney that authorized Mr. Steele to implement it. So she had no interest that Mr. Steele couldn't lawfully transfer. And if there were, you know, problems in the form of the deed, it's not entirely clear that they'd be a basis for relief to her. I think that's the gist. And again, I'm not saying it's not a correct argument. I'm just asking you kind of what's the thrust of your response arguments to take that form.
My argument is simply, you can't convey what you don't have. Aquarius Enterprises LLC is not on the property.
Ma'am, sir, if your client has no interest in the property, then she's got no reason to be complaining here at all.
But Your Honor, she still had an interest in the property until it was conveyed to someone else. And let me say that the proper way to do this, if they wanted to.
I'm going to ask you a hypothetical to make sure I understand your argument. So let's say that I execute a power of attorney for you to sell my house. And you go and you execute a deed to sell my house to some third party. And as the grantor on the deed, instead of writing my name, you write some other incorrect name. And then I come in and I say, okay, invalidate that deed. It has the wrong name on it. It says, you know, John Smith sold the property, which never happened. Am I in a position to complain about that, or am I not, because I authorized you to sell and you were trying to sell? And if there were, you know, technical defects in the name of the grantor, maybe I'm not in a position to complain. That's the question. You think in that hypothetical, I'm in a position to complain because John Smith never had anything to convey. Is that right?
Well, I'm not sure that I totally understand your analogy, but let me simply say this, that in my basic way of seeing this, the way to handle this could have been done very simply, but we're dealing with a fraudulent situation, so nothing's ever going to be simple and clear cut. If Ms. Plater wanted to convey the property to Classic Cottages, number one, she could have done it directly. Okay, sign a deed over. Secondly, the way that Mr. Steele could have done it was also simple. All they had to do was convey the property to Aquarius Enterprises, LLC, and then they could have conveyed it to Classic Cottages. That's not a stretch. That's not difficult. And look, Your Honor, let me just say something about the names, because this is like a shell game. Why do they have the name Aquarius Enterprises? I'll tell you why they have the name Aquarius Enterprises. They have it because they wanted to because the chain of title had the property in the name of Aquarius Enterprises sole proprietorship. Okay, and they wanted to hook into that and so forth and make it look like this was a continuation of a chain of title and so forth. So they come up with the name Aquarius Enterprises LLC to confuse everyone who looks at it, so that it looks like a chain of title and so forth, when it's not. First of all, Aquarius Enterprises sole proprietorship can't even own property and so forth. So that was part of a scheme to make it look like there was a continuation of the chain of title, when it wasn't. I mean, this whole thing is like, I'm telling you, a shell game.
The ones I thought your client purported to transfer the property from herself to Aquarius as a sole proprietorship. Wasn't that a deed that your client indisputably executed?
Correct.
I thought it was.
Correct.
So how is that part of the scheme?
The name Aquarius Enterprises.
No. I thought that transfer itself was defective and was part of a scheme.
I'm saying, Your Honor, that there are two Aquarius Enterprises. There was the one that Ms. Plater basically transferred to herself, okay? Because sole proprietorship is basically the same person and so forth. And technically, it cannot own property, plain and simple, okay? So.
I understand there were two. I understand the second part of the scheme. I just thought you were saying that first step was part of some scheme, but that was
no.
That was not part of the scheme that you allege. I got it.
The second part was part of the scheme, to use that name, to co-opt that name and make it look like it's a continuation and so forth. And they succeeded, because the people at the Recorder of Deeds didn't catch it. They didn't catch that there's a difference. They're looking at the name Aquarius Enterprises, and that was part of the scheme, and it worked, and it's still working today. But I mean, so at any rate, I think that we can't. There are so many things that were overlooked and part of this case, and as I say, the bifurcation issue is huge. And even when the motion from the defendants basically supports my position, and the judge's order and so forth is not specific, provides no specifics at all. It doesn't say, well, this is just going to deal with the single issue and so forth of the, it doesn't. It just says, well, we're going to bifurcate this. So, it's like, so many issues and sub-issues and so forth in this case that
Mr. Presley, I know that there are a lot of details, a lot of allegations of fraudulent transfers of property, and there are a number of different entities. But I wonder if, the question in my mind, and I think some of your responses to Judge McLeese are your answers to this question, but I just want to make sure. If there was no fraudulent power of attorney that was used in the transfer of the property, then do we get to reach the other issues that you want to reach? And as I understood it, the trial court's determination was no, that there's a presumption of regularity with the power of attorney, unless fraud or forgery are proven by clear and convincing evidence. And so when the trial court found that no forgery was proven, didn't that end the discussion? How is it that we then are able to go on to reach some of the other issues that you're alleging regarding other potentially fraudulent actions here? That's the piece I keep, because that was my understanding of the whole purpose of the bifurcation. We decide this, if there's forgery, okay, then we can get into some of these other fraudulent allegations or allegations of fraud.
But Your Honor, what I'm saying is that the bifurcation was not just limited to that one document. It wasn't. That was not part of the agreement of the bifurcation. I pointed you out to discussions where I made that clear and so forth with respect to my position. I pointed it out with respect to the motion to bifurcate, which supports my position. And just fundamentally, in terms of fundamental fairness and so forth, it seems as if I should have, Ms. Plater should have the right to argue all of the other things and so forth in the case. There's been no consideration of how bogus the so-called partnership agreement is, and the fact that there's another key thing here, and I was going to sort of go through some of this, and that is this whole thing started actually as a problem because of a failure to record the initial deeds that went from the estate to Angela Plater. And that deed was not recorded. Now, there was some problems and so forth with counsel, with Plater's, Conchita Plater's attorney at that time. He passed away. She unfortunately assumed that it had been recorded. It had not been recorded. That sort of led to another situation whereby when the deed from Angela Plater to Conchita Plater at some later point and so forth, that deed was also not recorded. Then it came a point when the deed from Conchita Plater to Aquarius Enterprises sole proprietorship was involved, and Ms. Plater wanted to record that deed. She couldn't do it because there was a problem with the chain of title and so forth. In other words, Ms. Plater was the owner at that point, but the records at the recorder of deeds indicated that she wasn't the owner and so forth. So in order to record the property and so forth, she indicated in the deed that she was the personal representative, which she was at the time. And
Mr. Presley, I'm sorry, I know we keep interjecting here. Who gets to decide what the parameters of the bifurcation were? I know that is it the trial court or you raised some concerns about what your views of what the bifurcation should be, but didn't the trial court set out the clear parameters of what the should consist of?
Let me say this, it's a question of fundamental fairness and an agreement. At the pretrial, we had a discussion and so forth. In other words, the court did not have the position, well, listen, I'm going to do it this way, and I'm just going to deal with the question of the power of attorney, whether it was forged, and that's it. And that's going to be the first part, and so forth and so on. That wasn't the way the thing was played out. It played out with a discussion among counsel and the court. And like what was read on page 20 and so forth, the judge said in plain English, we're going to try it with respect to the Simon Steele caper. You can't get clearer than that. I mean, if you look at the previous pages and so forth, you'll have to be able to put some meat on those bones. But he made it clear. We're going to try, what Mr. Presley said in terms of the Simon caper. what does that mean? It means what I was talking about in the previous pages. So there was an agreement and so forth. And I think that it would be fundamentally wrong to tell counsel that we have an understanding that that's what it's going to entail, and then get to the trial and it's something else. I mean, some people in the vernacular call that a bait and switch. It's fundamentally unfair. And for that to stand, I mean, that would just allow
agreement between counsel or an agreement between the trial court and counsel?
Frankly, Your Honor, between everybody, because as I've indicated, the motion to bifurcate supports my position. In the motion to bifurcate, it basically said, we're going to, because they were concerned about an equitable lien and so forth in case the Ms. Plater prevailed and so forth. So they wanted to get their money back and so forth for what they put into the property, which was significant. But as far as they were concerned in their motion, it's two parts. It's their equitable lien and everything else. They didn't say, well, okay, it's only involving this single document and so forth and the equitable lien. They said the equitable lien basically and everything else and so forth. So we didn't have a chance to put on and deal with everything else. We didn't have a chance to deal with fundamental questions in terms of putting forth, things that were stated clearly in the pretrial statement.
That's why I want to make sure here. I mean, as I understand your position is that at the end of the bifurcation hearing, you thought you were trying everything but the equitable defenses and the like. So unless you're pointing to places during the trial where someone stopped you from putting on evidence, I assume you put on all the evidence that you thought you needed to put on for all of the legal theories that you think could provide a basis for relief for you. Is that right?
Yes, we put on some evidence and so forth. And unfortunately, Your Honor, that was just, it wasn't considered. It's like it wasn't put on. So it wasn't.
You were stopped from putting on any evidence at the trial that you thought was potentially relevant to all of your different points that you're saying you believed were being tried. So your issue is more that the trial court should have taken the current record and addressed your other legal theories in its ruling. But you're not saying there should have been additional evidence or anything like that. And if you're right on this, you're not asking for a retrial. You're just asking for a ruling on the evidence that was already introduced on the additional theories that you think should have been decided by the trial court. Am I right in understanding your position?
That's correct. And also in reference to the deficiencies in the ruling and so forth. Let me just mention one thing in that regard. The Georgia Notary Office, and this gets back to the authenticity of the document. Also, I have something to say about Judge Campbell's previous ruling with respect to the motion for summary judgment, in which he indicated that—
Was that, Mr. Presley? I'm sorry, was this an argument that you made in your briefs before this court?
Yes. Yeah, as a matter of fact, Your Honor, I spelled out everything very
okay, because
clearly.
We've asked you a number of questions, but we've also been very generous with your time today. And I know that you reserved some time for a rebuttal argument. So if you could perhaps take another minute or two to
Sure.
Make remaining arguments, and then we can hear from the appellees, please.
Okay. Your Honor, the Georgia Notary Office and so forth, because this power of attorney was supposedly notarized in Georgia and forwarded supposedly to DC. The Georgia Notary Office, basically in a nutshell, indicated that that there was no such person as this Joshua P. person and so forth, who allegedly signed the power of attorney. He didn't exist. And also that was determined not just by the name, but by the expiration of his—
No, it was not determined because the trial judge did not credit all the evidence that was presented. And in fact, the trial judge found that none of those irregularities disqualified the validity of the notary, of the power of attorney, in the absence of proof by clear and convincing evidence of the fraudulent signatures. So, yeah, I mean, that was, am I correct in understanding that that was what the trial court found there?
Well, Your Honor, a number of things. Can I just say point out very quickly what Judge, oh, here it is. If you look at page 68, it's from his ruling, the judge's ruling on the motion for summary judgment. He says, he says as follows. He says, Peter Thiessen, this is from the Georgia office, states that he, quote, performed a thorough search of the official records of notaries in the state and had determined that Joshua P., last name unknown, with an expiration date of 3/4/2012, has never qualified or been granted a permission to perform any acts as notary public in this state, end quote.
I'm sorry.
Now, the judge also, let me read just one last thing here. He basically says
is it
that,
where in the record is this? Because we can directly read this.
Yes, this is on page 68 of volume 1.
Okay, so we have that in the record and we can refer to it. And if you could make your remaining arguments, please, Mr. Presley.
Yes, he says that the power of attorney raises a genuine issue as to the authenticity of the power of attorney. And then later on, when it comes to the trial, he says that it's not relevant. And to go from saying that it's a genuine issue and so forth, and very important, and citing what the Georgia person read and so forth, it's just like day and night. And then also, this is the office that should be given some deference and so forth. That's the case in DC, and it's the same way. It should be the same way with respect to a Georgia office, which is in charge of notaries and so forth, and they have records and so forth. And this person doesn't exist. I mean, what? That's clear and convincing evidence to me, and it's strong and disinterested evidence. But I know my time is going by, and I just wanted to make that point.
All right, thank you, Mr. Presley. As we indicated, you have reserved some time for a rebuttal, so we'll have an opportunity to hear your rebuttal argument. Mr. Bressie?
Good afternoon again to the panel, and may it please the court, Nathan Bressie for appellees Michael Fisher, Sean Fisher, Wells Fargo Bank, and Roy Kaufman, trustee. I plan, as concisely as possible, I plan to address the points and arguments raised by appellant, but it would help at the outset, I believe. And because the panel had questions about bifurcation, it would help to discuss the complex nature of this case as it was presented to the trial court at the May 30th, 2019 pretrial conference. So at that time, Ms. Plater had her own quiet title action pending based on the alleged forgery of the power of attorney. The Fisher defendants and Wells Fargo Bank had affirmative defenses and also had their own counterclaim and cross-claims pending. And Robert Bunn, who was successor personal representative of the estate of Francis Plater. And Francis Plater was appellant's brother and the original owner of the property. Mr. Bunn had his own probate-related claims against Ms. Plater, brought by way of intervention. And Mr. Bunn was seeking damages on behalf of the estate for actions taken by Ms. Plater while she was still personal representative of the estate. So this was the nature of the case as it went to pretrial. It should also be noted that these probate claims of Mr. Bunn essentially the second part of the bifurcated case. These claims of Mr. Bunn were tried before Judge Jason Park earlier this year in January. And Judge Park concluded on March 10th, 2021, entered oral findings of fact and conclusions of law that Conchita Plater did breach her fiduciary duties to the estate when she conveyed this property from the estate to herself while she was still personal representative through her sister Angela Plater without court approval. And the court did enter damages against Ms. Plater and in favor of the estate on that claim. So it was through this background and through these multitude of claims that the trial court took up the issue of bifurcation at the pretrial conference. And it was at the pretrial conference that the trial court discussed the court's intention to hear Ms. Plater's forgery claims first. And the trial court discussed its understanding that a ruling on Ms. Plater's forgery claims could very well be dispositive of her entire case.
Now, is that memorialized in any of the record that the trial court's intent and understanding was that the bifurcation and resolution forgery claim would be dispositive in his view as to whether or not you could go on and address some of the additional fraudulent claims? And if where would we find that?
Yes, Chief Judge, it is. And as I believe Judge McLeese pointed out on pages 16 and 17 of Joint Appendix Volume 2, which is the transcript of the pretrial proceeding, and I know Judge McLeese quoted from it, but I'll just quote again. The court said, if, for example, I were to conclude as the fact finder that Ms. Plater had, that she in fact signed these documents and authorized Simon Steele to do the conveyances that he did, then that's the end of your affirmative case, I think, correct? And Mr. Presley goes on to say, well, the court then says, which is a quiet title and declaratory judgment and so forth, right? Mr. Presley then says, well, I'd have to say you have a point. So it is clear there, the court is stating its intention and its understanding that the court's ruling on the forgery.
So the conversation does continue, right? And then Mr. Presley kind of qualifies and says, let me back up a little bit because there's more, right? And that's when he talks about the bogus Aquarius enterprises and talks about the illegal conveyance. And so then we get to page 20, which is what I was focused on earlier, where the court says, let's keep these things. And I guess the question is, what are these things separate? And he says, let's try the forgery case and the Simon Steele caper. And there's a comma in the transcript that keeps tripping me up. But it seems that he's talking about the forgery and the Simon Steele caper together. The Simon Steele caper, I guess, being an allusion to the illegal transfer. Do you disagree? I mean,
No, I do not disagree. The Simon Steele caper was the allegedly forged power of attorney. That's
no,
what the case.
I don't think so, though. I mean, because in the past 3 pages, Mr. Presley has just explained that there's more than the forged power of attorney. And it seems to be that the court is saying, okay, sure, we'll do all of that together, the forgery and the Simon Steele caper about transferring the property from an entity that didn't actually even own it. So that's what's tripping me up here.
Well,
is there anything, in answer to the Chief Judge's question, is there anything in writing subsequent to this that makes it clear, no, we're just going to talk about the forgery?
Not in the pretrial hearing transcript, Your Honor. But I would add the arguments about this purported break in the chain of title, they're really not part of the Simon Steele caper, in that the Simon Steele caper, according to the appellant, was the alleged forgery of the power of attorney, the alleged false creation of this Aquarius Enterprises general partnership, and then the conveyance to Classic Cottages. Now, the appellant at trial was authorized to and was allowed to put on any evidence on these issues that Ms. Plater wanted to put on. The trial court did not limit the evidence that Ms. Plater could have put on to show, either by direct or circumstantial evidence, to show that the power of attorney at issue was a forgery. And as noted in the party's joint pretrial statement, Ms. Plater actually introduced stated that she planned to call several witnesses at trial to support her claim that the power of attorney was a forgery. She said she planned to call Simon Steele, the alleged forger, Andre Ellis, sole beneficiary of the estate. She planned to call Angela Plater, her sister, and Irene Dolphin, who was the settlement attorney for the conveyance to Classic Cottages. And it is also worth pointing out, Ms. Plater, of course, had the option of calling an expert witness at trial to offer opinions about this alleged forgery, but Ms. Plater chose not to designate any expert on that subject. So at trial, even though Ms. Plater was allowed to put on whatever evidence she would like to put on as to the Simon Steele caper, she only chose to call one witness, which was herself. And at trial, and this is particularly worth noting, at trial, Ms. Plater also introduced an affidavit from Simon Steele, the alleged fraudster for all purposes. That affidavit is located at page 178 of the Joint Appendix, Volume 1. And Mr. Steele's affidavit, which again was introduced by the appellant at trial, specifically contradicts Ms. Plater's version of events. And it specifically states that Ms. Plater executed the power of attorney, that she authorized Simon Steele to convey this property to Classic Cottages, that the power of attorney was FedExed to the closing and received on the evening of the closing, and that Ms. Plater received very substantial proceeds from the sale to Classic Cottages. So at trial, Judge Campbell found Ms. Plater to be wholly incredible, and also found that the primary piece of corroborating evidence that Ms. Plater presented at trial to support her forgery claim, and that was this letter from the Georgia Court Clerk's Authority, and that is page 183 of Volume 1 of the Joint Appendix. The court also found that that letter did not present sufficient circumstantial evidence, or really any circumstantial evidence at all, that the power of attorney was a forgery, either by clear and convincing evidence or a preponderance of the evidence. And after Ms. Plater's case in chief, the court properly entered judgment in favor of appellees and quieted title in this property in the name of the Fisher appellees burdened by the Wells Fargo deed of trust. I did want to address the issue of the purported breach in the chain of title. And Judge McLeese asked about this during appellant's presentation. Here, the court's conclusion that the power of attorney was genuine was fully dispositive of all of appellant's claims at trial. Now, putting aside the issue of whether appellant ever pleaded that she was entitled to relief based on this purported break in the chain of title, here on that issue, pursuant to the doctrine of estoppel by deed, Ms. Plater is estopped from taking the position that title did not pass to Classic Cottages on December 7th, 2011. And she is estopped because, based on the power of attorney, which the trial court did conclude was genuine, the appellant herself authorized the conveyance of the property to Classic Cottages through the power of attorney. And Judge McLeese did discuss this issue during appellant's presentation. So by raising this issue of this alleged break in the chain of title, what appellant is essentially arguing is that even though she granted Simon Steele a power of attorney to convey this property, and I understand she continues to say she didn't, but that was the finding of the trial court. Even though she received sales proceeds from the sale of the property to Classic Cottages, And here again, I would invite the court's attention to Simon Steele's affidavit, which was introduced by the appellant at trial. Even though Ms. Plater authorized the sale to Classic Cottages, executed a power of attorney, received proceeds from the sale, she should now be able to essentially reclaim the property because of what she contends is a technical error in the name of the grantor. That technical error is Aquarius Enterprises sole proprietorship versus Aquarius Enterprises general partnership. And this is really the purpose of the doctrine of estoppel by deed. And that states that when a grantor or a privity of a grantor conveys real property through a deed to a grantee, the grantor cannot then later attempt to deny the conveyance or reclaim the property based on some purported error in the deed. And here I would invite the court's attention to, this is cited in our brief, 31 CJS estoppel and waiver, section 9. It's a very good discussion. I won't quote it, but it's a very good discussion of estoppel by deed. Estoppel by deed was also recognized in Ackerman versus Abbott, which is cited in our brief. Mr. Presley did have some arguments about the Georgia notary letter and the weight that was given to it. And this is page 183, volume 1 of the joint appendix. And as I'm sure the panel has seen, the notary letter only indicates that Joshua P., last name unknown, with an expiration date of March 4th, 2012, has not qualified or been granted a commission to perform notarial acts in the state. But there was no evidence in the record at trial, and this was a specific factual finding of the court. There was no evidence in the record at trial that the notary was named Joshua with middle name P. And the court specifically stated this in its findings of fact. The court found that the appearance of the notary's signature on the power of attorney, it could have read Joshua B or Joshua R or Joshua with a last name beginning with a P or a B or an R or several other letters. So the court properly did not give that Georgia notary letter any particular weight. I have some additional points about the presumption of validity of the power of attorney, but my time is running low. So if the panel has any questions, I'm happy to answer them. Chief Judge, you're on.
If you would address one of the points that Mr. Presley made in response to my comment that our statute does require and afford a presumption of validity to the power of attorney. I believe, and if Mr. Presley can correct me on rebuttal, but I believe Mr. Presley's response was that presumption can be overcome, not just with the clear and convincing evidence that it was a forgery, but any other qualifying evidence. And I think I'd like for you to respond to whether the statute provides some additional ways in which to rebut the validity of the power of attorney.
Certainly, Chief Judge. And it is true that DC Code Section 42404C does provide that nothing in the curative statute shall be construed to validate an instrument with respect to any instrument where there is misrepresentation, fraudulent act, or illegal provision in connection with its execution or acknowledgement. But the purpose of this statute, and this is reinforced in case law that has analyzed this statute, and I would point specifically to Bynum versus Equitable Mortgage Group, as cited in our brief. The purpose of this statute is to make clear that, for instance, if the notarization itself of the power of attorney, if that was fraudulent, you cannot then validate the power of attorney by recording it and waiting 6 months. And the same is true with the execution of a deed. If a deed is forged, you can't validate a deed by recording it and waiting 6 months. But here, the appellant at trial did argue that the notarization of the power of attorney was forged. The appellant put on evidence on that issue. The letter from the Georgia Notary Office was put on specifically to I would submit, to try to prove that there was no notary, Joshua, that this was a forged notarization. The appellant put on that evidence. Judge Campbell weighed the evidence properly, and Judge Campbell entered judgment against the appellant and in favor of appellees and quieted title in the name of the appellees. And I'm happy to discuss the Bynum versus Equitable Mortgage case more, but I am cognizant of the time.
All right, thank you, Mr. Brise?
Brizzy, Your Honor. Yes, thank you.
Brizzy, okay, thank you.
And I would submit to counsel for appellees 5038th Street and Classic Cottages.
All right, Ms. Wiggins, did you wish to make any additional argument on behalf of the appellees?
No, Your Honor. I rely on what Mr. Breezy has tried to.
Thank you. Mr. Gallagher, did you wish to add any additional argument on behalf of the appellees?
No, ma'am.
All right, thank you. Mr. Presley, I think you reserved a couple minutes for rebuttal. You're on mute, Mr. Presley.
I'm sorry. Yes, I did, Your Honor. With respect to Mr. Bressy's testimony, he agreed that there wasn't a limitation with respect to the bifurcation to the one single document issue. He mentioned something that, to be quite honest with you, I found astounding. He indicated that Ms. Plater received proceeds from the sale of this property. And there is no real evidence to support that. She, in fact, did not receive anything. And in reference to that, at the trial, defendants had literally gotten hundreds or maybe close to 1,000 pages of bank records from Ms. Plater to basically try and smoke out whether or not she did get some proceeds. They presented absolutely no evidence to support the fact that she received anything.
There's the Steele affidavit, right?
Yes. Okay.
I mean, I'm sure they were looking for it, but the affidavit is the evidence that she got paid. The
Okay,
affidavit
let me say this.
that you all put into evidence.
I could talk for hours about the credibility of this gentleman, Mr. Steele, but
I'm sure you could, but you put his affidavit into evidence.
Because there were other things and so forth in his statement and so forth that belied the validity of the partnership agreement, for instance, just totally inconsistent with the partnership agreement. The big story point.
What to say about the credibility of Mr. Steele? First, your statement was there was no evidence to receive compensation. Would agree that in fact there was evidence that she received compensation.
Okay, let me. I was about to finish the point about the bank records and so forth. Bank records are objective. The banks have no dogs in this fight and so forth. That's something that I think everyone could agree to trust and so forth. And if somebody got money, we're talking a lot of money and so forth. And as I said, they got all kinds of stacks of bank records and so forth from, Mr. Steele frankly indicated that he had not provided, and I can't put my hand on the exact document at this point, but it came out that there were no funds sent to provided to Ms. Plater. They found nothing in her bank records and so forth that indicated that she came across some windfall and deposited it and so forth. They had records that it went to Mr. Steele and so forth. Now he says that in his affidavit, quote unquote, that Miss Plater came to him and he was supposed to receive a couple $1,000s to help her out. Okay, it's totally incredible, but yet all of the money goes to his account and so forth, not just a couple $1,000s. He got everything. Miss Plater got absolutely nothing. That's why I cannot understand how counsel could make that statement, but let me move on. Now, also, after the court's ruling, I impressed upon the judge my concern about the issues and so forth that I've raised in terms of, the Aquarius Enterprises LLC not owning the property and so forth, and a number of other issues and so forth. And he listened to me and basically said, well, it sounds like, Mr. Presley, you need to do a motion and so forth, which we did. I did a post-trial motion and so forth that is, it's part of the, yes, at page 102, the motion to alter or amend the partial judgment and so forth that lays out every single concern and so forth. There was an opposition filed that frankly didn't address hardly any of my real concerns that were mentioned in that motion. And I did a reply. And there has never been a response to that motion, a ruling, frankly, because what happened was the case was appealed. So it just went into the ether. And I think that as far as the Court of Appeals is concerned, I know that courts of appeals like to have things where the trial judge has made a ruling initially, and and then
Ask you a question. Maybe I missed it. Maybe I'm confused, but I thought in Joint Appendix 1 at 148, the trial court ruled on the new trial motion and denied it. Didn't really give a big explanation, so there's that. I thought the trial court had denied that motion.
No, that was the ruling, Your Honor, in the trial. That was not the pre-trial. That was not the post-trial.
In front of you, I'm at the paragraph that says, now therefore, consideration of plaintiff's motion to alter or amend the partial judgment, or in the alternative for a new trial, the motion be and hereby is denied.
What page is that you're looking at?
JA 148.
Oh, okay. I think the problem was that it wasn't. Well, let me say this. I looked at the docket last night in preparing, and I didn't see an order. That's why I made that statement. But looks like it was an order. It was. Anyway, okay. I accept that. It frankly, Your Honor, to be honest, if you look at my motion and so forth, none of the issues and so forth that I laid out were addressed in this order. So it is what it is. Let's see. Also, in reference to the Joshua P. Issue and so forth, the Judge Campbell himself indicated that it was Joshua P. and so forth. And I can point to that reference. Yes, on page 68 of volume 1. Judge Campbell said that the name of the notary on the power of attorney is only partially legible. The first name appears to be Joshua. It appears that either the middle initial is P or the last name begins with P. I think it's very important too, if you look at Judge Campbell's ruling and so forth with respect to the important Georgia notary document, he is not, well, he basically tries to say that, we're not sure, it could be Joshua this, it could be Joshua that, and so forth. He neglects the point that the Georgia notary determination was not only based on the name and so forth. With anybody with that name, Joshua P. and so forth, it didn't matter what came after that. They don't have anybody, but it was in addition to the name, they relied on the expiration date. That's something that is digital and so forth. And it has nothing to do with the name and so forth. It's an addition and so forth. Now the judge didn't look at that. I mean, there has to be standards and so forth with respect to
So Mr. Presley, your argument is essentially that the judge's ruling and failure to credit this affidavit from Georgia or to give it further weight was a clearly erroneous factual finding on the part of the trial judge. Is that?
Yes.
Okay. Is there anything else? We have exceeded your 2 minutes substantially.
I'm sorry, Your Honor. There's one other thing. The counsel mentioned the regulation 42-404 and 404C. And it says that nothing, as he indicated, nothing in this act shall be construed to validate an instrument with respect to which there was any misrepresentation. And let's stop there. In this particular document, there were misrepresentations. The social security number was incorrect. It wasn't Ms. Plater's social security number. Why would she do that? Why would she put down a social security number that's incorrect? She didn't have to have a social security number on that document, period. It has multiple dates and so forth on it, which is incredible. And it doesn't comply with Georgia law, which is means that it's illegal in Georgia. So basically, there is more than enough evidence to support the fact that there shouldn't be a presumption. And also, if one looks at the surrounding circumstances and so forth, you will see that there is so much that is just wrong and bogus with respect to the so-called partnership agreement and so forth. It states things and so forth that were supposed to happen. They never happened. The dates and so forth, it's dated 2009. She didn't even know him in 2009. He says himself in his affidavit that it took place, that it was signed in 2011. So it's just all of this stuff that is being ignored. It's incredible that, and also finally, you have a situation where the errors and things that Ms. Plater did and so forth were problems that related to the property in the family, staying in the family, going from one person to the other person in the family, and the sole heir wanted that to happen. However, the other things and so forth that Simon Steele is concerned about is getting the property and so forth outside of the family. It has nothing to do with, at any rate, and I just think that Ms. Plater would just like a fair shot in terms of a fair assessment of everything that happened and all of these other issues and so forth. Now, also, let me say lastly that with respect to approving misrepresentation and so forth, that doesn't have to be at the clear and convincing standard and so forth. That's preponderance of the evidence. And if we were allowed to put on this evidence and so forth, with all of these things that just cry out fraud, and just look briefly at my post-trial motion and so forth, which lays out everything. And I'll end with that. And thank you for your patience, Your Honor. I appreciate it.
All right, thank you, counsel, for your briefs and arguments. And the matter is taken under advisement, and we stand at a recess. That was the final of the first 3 cases. We do have a special sitting this afternoon at 2 o'clock, and we'll reconvene at that time. So counsel, you're free to exit the virtual courtroom at this time.
This court is
Thank you,
now
Mr. Mayor.
adjourned